Your Lordship recollects that this is that habeas corpus matter where a same-sex couple wants to be together.
Yes.
My Lordship was pleased to direct that the parties should meet. My learned friend has told me that they are not willing to meet. He said that the girl is unwilling to meet, which I truly suspect. So, my lord, I'm praying kindly passes a direction for production of the girl, either before your lordships or before the learned magistrate. Already her statement is on record, 164 statement. Lordship recollects in her 164 statement, she clearly can categorically say that I want to stay with the petitioner. My lord, every passing day is a torture on her because she is staying in confinement. Grateful, my lord.
Why didn't you sit with him?
My lord, actually, what happened, my lord? Last Friday, my lord. Last Friday, kindly ask my lord. I told that my lord, actually this Friday, this Friday, most probably we will meet and we will consult with the same, my lord. Actually, what happened, my lord? I have some document, my lord, the relevant documents, medical ground, my lord. So he has most probably attacked with the dengue, and some documents he has been already tested, my lord. And my lord, or not only that, some medical ground, my lord, medical papers, my lord. He has been consulted with the doctor, and which is going on, my lord. Kindly see, my lord. And my lord, on the other hand, my lord, father tried yesterday, Sunday, my lord. Father went to my chamber and he tried with best level, my lord. My lord, not now that the victim, the girl, not my lord, willing to come to the Kolkata, my lord. My lord, he is very much afraid of, and he's saying, my lord, no, I will not go. But forcefully, due to his serious illness, my lord, forcefully he is taken. My lord, if the direction is given by your lordships, then other way, my lord, you have to produce. My lord, this is the difficulty. Kindly see my lord, the medical documents, my lord. I'll see, my lord.
Since when she is suffering?
My lord, the attack with that most tested with some documents, my lord, and my lord also the. এটা না এটা একটা আছে এই যে দিচ্ছি দাঁড়া and she is not at present now willing to come.
Who is Srimanto Moli?
Srimanto Moli, father, my lord.
So why you are giving health card of the father?
Last, my lord, last second page. That is the second page, my lord. That is a service holder at the university. His name is even card has been issued. Some test has been given, and test he already completed the test. The report, he has not received the report, my lord, and suffering from fever, my lord. And one doctor, which has been consulted with the doctor, my lord, which is going on. Physiotherapy is going on.
Where is the 164 statement?
Mr. Moore,
Case diary the one. Case diary.
164 statement. Have you got the record with you?
Lordship, today I do not have any fresh report. The report which was submitted in the last occasion, that is the only report I have got.
No, we have not taken the 164
No, I don't think so.
statement.
No, এটা তো কেস ডায়েরিটা নয়, কেস ডায়েরি।
Case diary is not here with me. নেই নেই এখানে নেই, এটা petition. Case diary is not here with me.
Show the medical document to Mr. Gupta.
My lord,
Show it to Mr. Gupta.
মেডিকেল ডকুমেন্টটা দেখান আছে।
On 27th, she was suspected dengue.
Take this copy, take this.
Yes,
copy.
my lord, as far as it is not clear whose dengue, whether the father or the girl.
yes, yes, it is true, my lord. I have said,
Paper,
and I have signed, I have also.
Huh. Yes, I have the original.
এইটা
He has given me the original.
অরিজিনাল যে এইটা আছে বস এইটা
My lord,
একটা ডক্টর আছে which is going on, treatment is going on date wise. It is different, এর সঙ্গে এটা কোনো মিল নাই।
my lord, if this is, my lord, kindly sees, my lord has seen this, my lord.
No, no.
এটা একটা কপি দিন সাহেবকে দিয়েছেন। My lord, kindly takes this up, takes this document up,
Tell us, Mr.
take this document up. I do not have a copy.
আচ্ছা, দেয়া আছে, দেয়া আছে।
Yes. Yes, that is of Sutapa.
Cognitive behavior therapy, CBT.
Huh.
That is a psychiatric treatment.
Yes.
What?
no,
The
not
psychiat-
that.
But she's suffering from dengue.
Yes,
Yes, no, my lord, kindly sees the middle
Sir,
portion.
I've seen that.
So what is the purpose of undertaking a psychiatric treatment until and unless the father thinks that being, having a same-sex relationship is a disease?
These are all your apprehensions, Mr.
No, my lord, it,
Suppose you cannot, she is now with the father, but you are right. If she is willing to come and stay with you, there can be no bar.
my
We
lord,
appreciated your argument.
my lord.
We asked him to sit with you so that the matter can be resolved. Now, he says that he will come on Friday. And she says that she is suffering from dengue. So we will ask him to put these documents on record. And in the meantime, the 164 statement would be there. So in the meantime, if there is no settlement, we will pass appropriate order
Very
after
well.
vacation.
No, my lord, not after vacation. My lord kindly appreciates this.
Because of this reason,
better.
dengue won't be cured within 2 weeks.
My
You
lord,
will take time.
dengue can be treated better in Kolkata.
That is.
I will ensure treatment of my partners,
He has to come, my.
my partner's dengue.
Come Kolkata, then hand over the friend, my lord, and father knows.
My lord,
You speak.
Beg pardon, my excellent, beg pardon.
my lord, no, kindly not after vacation. Kindly, because I have reasonable suspicion, my lord, that after vacation, what condition this child, the alleged victim girl will be, we do not know. Because in several cases throughout the country, my lord, that certain substance is being administered to bring down the libido of the person so that they do not feel any desire at all. And that is extremely detrimental for their future health. The moment they stop feeling the libido, they do not feel the love, and they are under psychiatric treatment, and they are not in a position to take decisions of their own. My lord, I beseech your lordship, my lord, let a medical board be formed. Let she be brought in under medical supervision to Kolkata. Let a medical board be formed and treated in Kolkata.
Lordship, only one thing, Lordship, here there has been no representation from the petitioners. So the case which was registered, Lordship, that was actually filed by the father. Missing complaint, which has been accordingly, we have found the daughter and we have given a,
Registered as
Yes.
a formal FIR was lodged.
Yes.
yes, Lordship, in regard to the father's complaint, but not, there is no representation from
And
the petitioner.
she is accused in that.
Yes, I am accused in that. Challenging that, I have filed a 482 petition. Copy has been served upon my learned friend as well as upon the state. Justice Tirthankar Ghosh is not sitting till 9th. He will take it up after 9th.
Very good. You
My
try
lord,
your
that is
best.
one part
Yes.
with regard to. Now, if my learned friend from the state is saying that the girl was rescued, let her stay, and the girl was abducted, the girl was rescued. Kindly appreciates this, my lord. Lordship would kindly inquire from where the girl was rescued.
Lord.
And
So what do you want us to do? We will call a dengue victim in court and talk with him.
no, my lord,
Then what do you want?
my lord, my prayer is,
He is a dengue victim. You expect the court to call her in that ailing position and ascertain?
No, my
You
lord.
want to go with the boy?
No, my
So
lord.
why you are so impatient, sir?
No, my lord. May I? All I'm,
So first answer our question. If she is suffering from dengue, she will not be recovered within 2 weeks. It will take time. Can this court ask an ailing lady to come before us and say that what do you want?
my lord, if your lordship would permit me, my lord, I question the fact that she is,
If you question, that has to be decided.
my lord,
If
that
you
is to be,
question, if you question that she is hale and hearty, she is not suffering from dengue, where from you get this information, sir?
no, my lord, I am not getting this information. That is why,
That's why
assert,
we are calling him to put this fact on affidavit. He will put it on affidavit before us as regards the ailing conditions.
and my lord, may I pray this, my lord, only this prayer. My lord, your lordships direct a medical board be formed in the Bardhaman Government State General Hospital.
On the basis of a complaint lodged against you, the police authority has recovered the girl. Whether recovered or taken away, that is another affair. And the police authority produced the girl in a court of law. Thereafter, as per the order of the court of law, the police authority has handed over the lady to his father.
My lord,
Now, what is the illegal detention?
my lord, subject to correction.
That is the illegal.
My lord,
Whether you will do a revolution regarding such and such, that is another field. But where is the illegal detention?
my lord, kindly, my lord, I am not sure, my lord, from where your lordship has got this, that she was handed over as per the order of the court. My lord, as per,
How?
my lord,
How he has handed over?
I will tell your lordship.
How he has handed over?
I will tell your lordship,
Took the custody,
my lord,
produced before the CGM or a CGM, as the case may be.
my lord.
So how the father got the custody of the girl?
I will tell your lordship. My lord, on the day allegedly the girl was recovered, she was with me in my house. The police along with the father came to my house where both of us were residing. Kindly appreciate, my lord. The girl allegedly is recovered by the police from my custody. My lord, I put this question to myself. If the girl is rescued from my custody by the police, why did the police not arrest me in such a crime? Number one. Number two, the girl is taken to the learned CJM, and I am given an assurance that she will be giving a statement before the learned court, and after the statement is given, her fate will be decided. I agreed to that. I went to court separately. She was taken by the police. I went to court separately with her. Before the learned magistrate, your lordship recollects, on the last occasion, lordship has seen the 164 statement where she clearly stated that I want to stay with the petitioner. The learned magistrate told the alleged victim girl that very well, you can go and stay with the petitioner. The moment she steps in, she tells me that this is what I told the court, and the judge has told me this. Immediately in the court premises, police again takes custody of her and hands her over to the father. This is what happened, my lord.
So police has taken illegal custody?
My lord. Now, police, there is nothing on record. There is nothing on record to show that police has taken illegal custody, because police did not take custody as per law. Police just got hold of the girl and forced the girl to go with the father and shooed me off. Forcefully shooed me off within the court premises.
But there
This
has
is what has
Complaint before any authority that this incident has occurred?
no, my lord, because my lord, the first time when I went,
There is no complaint before any authority, no diary. We have to believe your oral claim, oral statement.
no, my lord. Therefore, my lord, I am praying. This is my prayer, my lord. Please do not believe me, my lord. I am praying that a medical board be formed in Bardhaman State General Hospital. Let her mental and physical health be checked up. Let the medical authority submit a report before this honorable court. Because I am raising a constitutional issue before a constitutional court. My lord, my only prayer, I am not asking for the custody of the girl, that immediately she should be handed over to me. This is my only innocuous prayer. Let a medical board be formed under government hospital, not any private doctor who will give a certificate just for the asking.
Where is your representation to that? where there must be some basis of your submission.
I'm grateful.
My lord, I have said this on,
You just cannot come up to the constitutional court and say, I will not go before any other authorities. You produce the girl.
no, my lord, I'm not asking for the girl to be produced.
That was your opening submission. That
Yes,
you call the girl.
Yes, my lord, if I bow down to what your lordship has held, or what has fallen from your lordship, I bow down. I'm only praying for a medical board.
What can be done?
But my only prayer is for medical board, both for dengue, physical health and mental health.
Yes, you oppose that. Let
No,
him file
no,
an
that is my prayer, my lord. My lord, for the state
We
government,
have to ascertain that we cannot sit as an expert body over of treatment, and there is no suspicion. There does not appear to be any suspicion that she is ailing. On what basis we will direct a medical board? You have to deny that condition which is expressed by the father by filing an affidavit before us.
my lord, this affidavit can,
File an affidavit
my
before
lord,
us,
my lord,
and if we find that your argument is acceptable, we will direct a medical board.
my lord,
People are not running away from this.
my lord kindly appreciates that it is not possible for
And in
me.
the meantime, he will sit with you, and if you can amicably settle, nothing
My
like
lord, there is no question of amicable settlement. There is no question of amicable settlement. The father paid local goons to beat me up. There cannot be any question of amicable settlement. Here, my lord, I am,
So you don't want to listen to what the court says, that you will make an endeavor for.
my lord, last time, lordships expressed that desire, my lord. I bowed down to it, my lord. Your lordship's order was dated 14/9. Lordship sees from when he was ill. If there were any intention of fulfilling this, immediately it should have been.
সেটা কোন রেকর্ডে আসেনি ট্রিটমেন্ট দেবেন না ট্রিটমেন্ট দেবেন on the basis of the apprehension that the psychiatric is attended by any psychiatrist.
The 164 statement is on record.
All right, you bring the 160.
In regard to the complaint of that father, because here there is no case, because as on date, we have not received any representation from the
No,
petitioner.
the document which you produced last time,
Yes,
you bring it to us tomorrow. You can bring it to us tomorrow.
Lordship kindly gives me one more day.
Because it is Bardhaman and it's raining heavily, my lord. So tomorrow might be difficult.
Tomorrow, if in case I am not being able to bring the record.
কিন্তু কোনো রিপ্রেজেন্টেশন
নেই
Lordship, I think that the girl has been
No,
produced
my lord,
because
charge sheet has not yet been submitted. Therefore, 164 will not be handed over.
after completion of it is a judicial order. We are talking about the judicial order which was passed by the
No,
magistrate
no.
after production
Of
and
160.
completion of recording of her statement under section 164.
My lord,
What order magistrate passed?
we do not have that.
So,
We do not have that.
you are
But
making submission based on the such and such the magistrate has said, has given liberty, you can go
no,
anywhere.
my lord, that is what the girl told me.
No, at
That is what the girl told me.
willing to go. They are friend. Willing to
Hearsay, absolutely hearsay,
She is not willing to.
absolutely hearsay.
Yes.
All right, we keep it tomorrow. If you have any problem, you tell us. Otherwise, we will, because my brother won't be here, because we have to hear it within this week. All right,
I'll try my best, Lordship.
let it be tomorrow. If not possible, then on Friday. It will be in the list.
Grateful, my lord. Grateful.
And Mr.
Lordship can kindly
Bhattacharjee,
pass a short order because it will be very easy for me to then to direct the.
no, dear, you are the officer of this court. You ask for the records to be brought, finished. We are not wanting the case diary. You have heard what my brother has said.
Wait,
Grateful, my lord.
সেটাই তো।
এই সম্পত্তি কি হবে? আমার magistrate দিয়ে দিচ্ছি, সেই স্কুলে মারা গেলে তার চাকরি পেলে তার appointment হবে।
64 টাকে জানলাম।
হ্যাঁ,
দিয়ে
করতে পারবো।
রিচার্জ করবো। সেটা
পরে করে।
সেটা পরে করে সেটা করতে দেওয়াটা এটা এই
নদী যখন পেয়ে গেছে, নদী যখন পেয়ে গেছে, তো ও তো চেষ্টা করবে।
দেখো কাল কি Yes,
My lord, with due respect, I'm submitting before your lordship. My client is not willing to not press the application. My lord, I will take 10 to 15 minutes time and thereafter lordship dispose of the application as your lordship may deem fit and proper. My lordship, in the instant case, my lord, first, my lord, the wife, my lord, lodged a complaint against me, and that is page 24. And thereafter, page 24, my lord, charge sheet. My lord, thereafter, page 17 onwards, my lord, 11 page 21. Thereafter, page 24, my lord, charge sheet submitted in the form of final report. Mistake of fact against my client. My client is a doctor. Thereafter, my lord, what has happened? My lord, child from the 2018, the minor child, female child, I'm a doctor with my wife along with another person. My lord, he has a extra relationship with that person first. Thereafter, what has happened, my lord? One after another, I lodged complaint. I came to their place, but now she and my child, my wife and child, along with that man, not traced out, not in the West Bengal. Probably he is in the Dhanbad. For that reason, I lodged a complaint before my lord, Dhanbad police station, that is in Hindi, page 83 onward, and my lord, in English, my lord, page 88, Dhansor police station. That is. Thereafter, my lord, in the meantime, I file an application under Guardians and Watch Act 8 before the learned additional district judge, first court, Purbo Bardhaman. That order, my lord, page 80, and all the order, my lord, I annex all the order, page 51 onwards. She did not come to the proceeding, my lord. After duly served, learned district judge, my lord, thereafter page 51 onwards, my lord. And ultimate order, page 80. Page 80, my lord.
where is your service upon the private respondents?
My lord,
Where is your service upon the private respondents?
my lord, yesterday,
You
no, my lord. Yesterday, I served I handed over the affidavit of service. But yesterday,
কোথায় এখানে নেই?
affidavit of service দুটো ছিল। না না করছি না, বললাম তো করছি না। মানে sorry, my lord. My lord, that affidavit of service, my lord, till now, my lord, dispatched, not served upon the private respondent, my lord.
Yes.
My lord, then, my lord, what has happened? Page 80, my lord, order. And thereafter, I communicated the order to the, my lord, Birbhum police station, as well also Purbo Bardhaman superintendent of police, as well also Dhaneshwar, Dhanbad. But, my lord, I failed to trace out my daughter, my lord. The unavoidable situation, one extra relationship with another person.
What did you do since 2021?
21, yes, my lord, grateful your lordship. From the 2021, my lord, court is vacant. The first court, Purbo Bardhaman, for filing of section 45 of the Guardians and Wards Act, my lord, I talked with my counterpart, court is vacant. Thereafter, only I made
It was vacant when?
from 2021. Last, just now, my lord, presiding officer joined in the first court of learned first court, Purbo Bardhaman. And my lord, but I made several representation. I tried my best, my lord, to trace out my daughter, my lord.
We understand, Mr. Chakraborty, you have adopted the correct procedure. Now, on the basis of evidence, there is a finding of custody in your favor.
My lord,
Now, we cannot usurp the jurisdiction
but
of
on the same point, my lord, I am relying upon that, no, not, my lord, binding upon your lordship. This is the division bench judgment of the Karnataka High Court. Persuasive value is there. If your lordship kindly have a look into that judgment, my lord, unreported judgment, and I served a copy upon her. তিনটে আরেকটা দিন কটা করেছি
invitation এর ব্যাপারে
এই ওনার জন্য আরেকটা করতে হতো তো ওনার জন্য আচ্ছা আচ্ছা এই নিয়ে
custody-টা
মাই লর্ড
violation এর জন্য কি যেতে
এই বইটাও দিন
search warrant
my lord, that judgment, first paragraph 3, my lord. It is not in dispute that the aforesaid order passed by the family court was challenged by the wife in a family court passed an order by the wife in an appeal under section 47C of the Act, that is such and such number. The aforesaid appeal was decided by judgment dated such and such. The judgment of the family court has been upheld. The operative portion of the aforesaid judgment passed in MFA reads as under. The appeal is dismissed. We feel that interest of the minor child will be best served if the custody of the child is handed over to the respondent, but with sufficient access to the appellant to visit the minor at frequent interval, and therefore such and such. While confirming the judgment and decree dated such and such passed by the family court in number filed by the respondent under section 25 of the Act, and directing appellant to grant custody of the minor child to the respondent. We are inclined to grant visitation right to the appellant, though he has not prayed for the same on the following terms. My lord, thereafter kindly come to paragraph 6. Paragraph 6. In other words, the order appointing the husband as guardian of the minor daughter and a direction to the wife to hand over the custody to the husband has attained finality. Thereafter, paragraph 7. However, despite the fact the order of the family court directing handing over the custody has attained finality, the custody of the daughter has not been handed over to the petitioner. Thereupon, the petitioner filed this writ petition on or about 11th April 2023, seeking the relief as stated supra in this writ petition. A division bench of this court passed an interim order directing the issuance of non-bailable warrant to secure the presence of wife. The said order was challenged by the wife in SLP such and such number. Therefore, said special leave petition has been dismissed on 16th May 2023. In the light of the direction content in the order dated 16th May 2023, passed by the Honorable Supreme Court, the wife appeared before this court along with the daughter. Thereafter, paragraph 8, learned senior counsel for the petitioner submitted that the judgment and decree dated 3rd March 2022, passed by the family court, attained finality as the aforesaid judgment and decree has been appealed in an appeal not only by a division bench of this court, but by the Honorable Supreme Court as well. It is submitted that despite dismissal of the special leave petition, custody of the child has not been handed over to the petitioner, who is legally entitled to the custody of the daughter. It is further submitted that
Yes, we have read it. Miss Molly, have any case been registered subsequently?
Subsequently, yes, on the basis of his complaint, a case has been registered, Lordship.
So do you have you ascertained where the whereabouts of the person?
Yes, Lordship, I'll just hand over the report, Lordship. Pardon me, Lordship, I just only have one copy of the report, Lordship. Second page, second paragraph, Lordship. I mean, the second last paragraph, Lordship. Here, the wife has stated that she doesn't want to return to the petitioners, neither the child, because they have been undergoing tremendous torture, physical torture after the marriage. And she has denied to disclose her present abode. This is the report, what we have received, Lordship.
My daughter was rescued from the channel and gave her custody. It again. She was found well because the kidnapping case against him, Dubraj, her minor daughter was rescued from the picture. The daughter was taken away by the father at one
At
juncture.
one time, yes, yes. Upon the complaint of the mother, the police recovered her, and again,
When did that happen?
page 24, my lord, FIR. FIR lodged by wife. Sorry, page 17. 11 page, my lord, page 21. মহাশয় আপনার বিনীত নিবেদন আই যে আমি রূপালী রায়চৌধুরী বিজয় চৌধুরী
Wait.
page 21. That FIR final report submitted, mistake of fact. But police handed over the child.
Police handed over the
Handed over the child from me, but submitted final report, mistake of fact against me. That is, I have annexed that document.
Then what happened?
Then what happened? I lost the complaint.
The child was with you then?
No, handed over to mother. From till 2018 with me. After 2018, he lost the complaint. She lost the complaint. Why? That is page 21. And during the investigating proceeding, my lord, child handed over to mother from me. And my lord, thereafter, ultimately, final report submitted against me, my lord. That is page 45. Thereafter, I another, sorry.
Lordship, till
And that
2018,
charge
all of them were residing together. The wife was also residing with him only.
Along
Till
with-
2018, the wife was
Yes.
also residing.
Along with another man.
The whereabouts of the petition of the respondent is not known to
Not-
anyone.
no, she has refused to disclose, and
Yes.
she has refused to disclose, Lordship. She has said that there has been tremendous torture in this marriage. That's why she doesn't want to return. Neither she wants to hand over. And she had no knowledge about that ex parte order of guardianship
Copy
under a
staff.
guardianship act.
And reflect from the order of the learned district judge. The copy served. Thereafter ex parte. That is
Custody at present is what is the age of the
2008 born.
2000, my lord, that,
Eight born,
that
Lordship
birth
takes
certificate with me, my lord,
15 years most probably.
15 years. I annexed the birth certificate also, page 16.
so the child is reading at Dubrajpur High School.
Yes, yes.
So why can't the police ascertain her whereabouts?
Lordship, what?
Is on your record.
Yes,
that
Lordship,
it is
I
Dubraj-
bow down before Lordship because whatever has come, I had to place before Lordship. But if Lordship gives direction, we'll just.
Only enroll the name. My instruction is that only enroll the name in the Dubrajpur now at Dhanbad, my lord. That is, I that for that reason I lodged a complaint before that police station, Dhanbad. Also, that is Dhaneshwar police station, Dhanbad, page 88. And in Hindi, page 85 onwards.
we will be acting on accepted procedure. কিন্তু কর্ণাটক হাইকোর্টে তো করে দিয়েছে এখানে কাস্টডি অর্ডার স্টে অনেক অ্যাপ্লিকেবল হয়েছে ওতে কোনো চ্যালেঞ্জ হলো এক্সপার্টি অর্ডার যখন সেটিং অ্যাসাইড করতে পারতো তো সেটিং অ্যাসাইড করতে পারতো
তার আগে থেকেই আমরা তার মতামত দেখতে শুরু করি বাচ্চার তো একটা মতামত দাম আছে
সেটার এগেনস্টে তো একটা কিছু করতে হবে কোর্ট তো নিজে থেকে রিকল করবে
Service upon the private respondent have been effected.
No,
affidavit of service filed by the petitioner be kept on record. It appears that service upon the private respondents is not complete. Stop. In view thereof, the petitioner is directed to serve a further notice upon the private respondent numbers 7, 8, and 9. Intimating that the matter will be taken up for further consideration on 17th October.
as well as police, my lord, as well as
Yes,
I will serve, my lord,
efficacious alternative remedy.
my lord.
Yes. Lordship,
You
that
know-
was what I was supposed to place
Yeah,
Lordship under section
alternative
25.
remedy.
My lord.
We have alternative remedy.
Remedy.
This is a special act. That's
Yes, my lord,
one
section,
act.
my lord, section 45.
45, 24,
25.
52,
In spite of that, my lord, your lordship,
45 or 47,
In Karnataka
Yes.
High Court judgment,
45.
the order attained finality. If it is a case that
yes,
this-
but the
this
order not attain finality.
So if she can establish that this order was passed without properly effecting service in Karnataka High Court judgment, which you cited before us, therein also challenge was made against the order granting custody. It went up to High Court, it went up to Supreme Court, then but during the entire tenure, the minor was not produced. And in view of such exceptional circumstances, the procedure under the Special Act was bypassed and court directed you produce. But that is not a fact here. There is a subsisting matrimonial dispute between the parties. These bickerings cannot be resolved. You have taken an order, so now the custody with the mother is illegal custody. In view of the order, it is illegal custody. So it is your duty to bring this to the notice of the court. Immediately search warrant will be issued. How will you be benefited? I do not understand. That will only, what happened? This will be killing time. Now the presiding officer.
So I
is
am
going-
only praying for production of the child. Now he is 14 years old. As
15.
my lord,
50.
15, 14, 15
So
years old.
That production.
Hard statement, my lord, then after now no case, my lord, kindly dismiss the past necessary order. My lord, if your lordship, whether he is in the, my lord, Birbhum, kindly direct the police to record a 164 statement
Even section 17 not complied with. 17 of Guardian of WhatsApp.
Yes, my lord, that is,
Actually, the opinion of the girls is to be taken, opinion of the minor is to be taken.
three-time copy served in the learned district judge court. Thereafter, expertise order never come. And today also police said he did not disclose the address, my lord. Problem, real problem, my lord. Act is there, I know, my lord. My lord, real problem, reality, my lord, ground level reality, that we have tried our best. Even the court also tried to serve the copy, my lord.
For that the remedy is available to you. For that the
My
remedy is
lord,
available.
only direction to production of the girl. I am not praying for, my lord, according
Then
to
nobody, everybody will come and file habeas corpus here. That this court is not required, you take up the jurisdiction.
If the minor is old enough to form an intelligent preference, the court makes.
section 17 বলছে আরে বাবা জানি
Alternative remedy আছে. Remedy. Alternative remedy under section 25 to 55 efficacious alternative.
We are disposing it of, we are giving you the liberty. You approach the court below and take it.
my lord, before dispose of the application, my lord, one Supreme Court judgment referred by the Honorable Division Bench of the Karnataka High Court. That judgment, my lord, kindly have a look into that judgment, and thereafter,
Please judge.
no, that judgment in the Karnataka High Court judgment, one Supreme Court judgment was referred. That judgment, lord, kindly have a look into, thereafter dispose of that.
What was said? What was
But
said?
here also, my lord, in the foreign, your lordship already read the judgment, my lord. Foreign court passed an order in the USA, and thereafter the child is here. In the habeas corpus matter, Supreme Court directed to comply the implementation of that foreign court order, my lord.
We have that is in the facts and
The facts and circumstances, but what my satisfied lordship kindly, and
Evidence
thereafter
was-
dispose of my application.
আচ্ছা দাও।
Section 14 sufficient. Section 14 sufficient competent court pass for it.
Here I am
গণেশ,
only praying for
this was
produce and trace the application. Produce and trace. Not traceable till today, girl child and mother with another man. And he also a married person. The, my lord, alternative remedy is there. I know, my lord. You know I'm better than me, my lord.
It is self-accurate.
Before your lordship, my lord Justice Chakraborty, my lord, I am submitting before your lordship. You know better than me regarding the right of the constitutional court, my lord. My lord, there are so many alternative remedies, but I am praying for only trace out my child, my lord.
You are bringing the
Even police did not trace out the child till today, my lord.
any complaint?
Yes,
Any complaint have you made
yes,
of adultery?
yes. And against that person also case was started. It is true, there are alternative remedy in the book, my lord. Into my lord, in ground level, my lord, lordship kindly visualize the position, my lord. Unavoidable situation for growing up a female child along with a group disturb of the railway employee. My wife is there. It is admitted fact. I lost the complaint, charge sheet submitted against that man.
page 81. Page 80.
Thereafter, my lord, lordship kindly passed the order.
Act as a enforcement agency.
There are so many acts,
Order
my lord.
of the district court.
There are so many acts.
Page 80. Page 80. সার্ভিস করে আসুক তাহলে।
সার্ভিস করে আসবে।
In spite of service, no, stop. It appears that service upon the private respondents is not complete. Stop. The petitioner is directed to serve a fresh notice upon the private respondents, respondent number such and such, intimating that the matter will be taken up for further consideration on where does it look, Raj? Further consideration on 12th of
পিটিশনটা করবে
on 12th October.
12th of
October.
12th October. And to
Grateful, Your
file
Honor,
an
grateful, Your
affidavit
Honor.
of service on the returnable debt. Stop.
I am grateful for patience hearing, my lord. 12th October.
What is the status of that case, Miss Mulli? You have
Regard to the
Last case, sir.
last case, Lordship. Lordship, the report is not very clear about it, Lordship. I can just come back with the proper instructions, Lordship.
did you have to report delete? Oh, wait a minute. Miss Maulik, learned advocate appearing for the state, is also directed to avail necessary instruction in the meantime. Please the matter for further consideration on 12th. Yes, next.
Grateful.
12th, your service may not be complete. It is
Then, my lord-
Yuvrajpur, na? Yuvrajpur.
We are not
16th করে দাও, 16th.
করেছি না
Complete the service along with this order. Yes. That your Supreme Court judgment in Ganesh's case was considered by us
in one judgment, my lord.
and we delivered the judgment.
My lord.
This case was
My
considered.
lord, next week, my lord, next. My lord, already considered.
You were there in that matter, I think.
No.
Yes.
Your Lordship, I am the petitioner father. My daughter, 8-year-old daughter, who is a severely autistic child, Your Lordship. And Your Lordship kindly comes to page number 19 of Annexure P2.
Service.
Your Lordship, the state has been served, Your Lordship. As per my apprehension, yesterday we went physically to serve the copy to the respondent wife. They are not traceable, Your Lordship. We did take the help of the traceable, Your Lordship. The house is locked. Again, they are missing. My wife and my daughter, Your Lordship. And unfortunately, Your Lordship, tomorrow is the date for dropping the passport for visa stamping. Passport, my daughter's passport is still with my wife, Your Lordship. I'm in a grave situation, Your Lordship.
An order from us to persuade the mother to take the child to Hyderabad so that visa attachment can be made and the child can be taken out.
Not the child can be taken, both of them can travel. Your Lordship, the child is undergoing therapies in USA. She's a severely autistic child, Your Lordship. Kindly see page number 19, Your Lordship, the diagnosis, which says level 3, autism spectrum disorder, level 3, requiring very substantial.
Her mother,
Your Lordship,
her mother, that mother's custody with mother is not an illegal detention.
agreed, Your Lordship. But
You are wanting us to pass an order so that you can take the child to US. We understand that.
Lordship,
But there is a matrimonial dispute between
Lordship,
and you have to, court cannot force the lady that you go and take the child to Hyderabad and go away with your husband. Can the court force?
Your
The
Lordship,
House judgment.
Your
must
Lordship,
have
kindly, if you, Lordship, this is not about me or my wife. This is all about the child who cannot speak for herself. And if Lordship,
the
there is,
date drops. Visa date will be a fresh visa date will be.
Lordship, that, as we all know, in autism, there is a limited period of elasticity when the brain can be, reprogrammed. Once it is hardwired, Lordship, she will have a very regressive life, your lordship. This is all about the therapy that we are talking. It's all about the life of that child, your lordship.
What order do you want from us today? Tell us.
Your lordship, the police should go and search the girl child and get the girl child brought should be brought to the court, your lordship, so that visa stamping. I'm not asking the girl should go to USA. The visa stamp, if it is not done, your lordship, she loses the opportunity to get back to the therapy. That is very important, your lordship. That's the whole.
Whether she's undergoing any treatment in India.
She is not, your lordship.
That is your allegation.
So, your lordship, the mother took the child on 13th of September without informing anyone. She took the child from USA, came to Kolkata. On 29th, when I landed in Kolkata, went to the home directly, I could see my wife and child are there. Both are there. But after that, again, they are missing, your lordship. And it's all about the.
Have you done anything?
Yes, Lordship, we have searched for her. She is in her sister's home, which is in Delhi, residing with the brother-in-law and the sister.
Thank you.
But what is the address in Delhi?
Lordship, again, Lordship will find that
Contacted over mobile. Your officer did not take the address. What sort of investigations you conduct, madam?
Lordship, unfortunately, again, the officer is not here. I'll just come back with the address tomorrow, Lordship. If Lordship kindly keeps it tomorrow, I'll come back with a, because the first complaint was received through email. It was on 17th September.
Yeah.
On the basis of that, they have initiated the proceedings and has communicated with them. Then subsequently, another complaint was received on 20th September. It was by a letter from the advocate of the petitioner. So, Lordship, in regard to the second complaint, after that, what they have done, there is no reflection. I'll just get the information tomorrow, Lordship, if kindly keeps it tomorrow.
Service you not. Let us bring the address tomorrow. Come tomorrow.
Lordship, much obliged, your lordship.
Since Lordship, the report was handed over, Lordship, can
Take it.
My lord, in this matter, I appear for the petitioners, my lord.
My lord, I am for the respondent number 8, my lord.
So this matter was heard on 25th September.
My
So
lord,
kindly have a look to the order once.
Yes.
yes, my lord, the form, my lord, we have got the form, my lord. I have,
Where is your senior?
my lord, we are for respondent number 8 and he was appearing for the other respondents.
Oh,
My
I
lord,
see, I see.
my lord, this is the form we have got. We have been able to trace out the
That
form.
is annexed.
No, my lord, not that, my lord. In 1971, my lord, he has exercised the option not to join the scheme. That I have got, my lord.
That-
The list I have got, my lord. From the your lordship's
that
order was
Lord, that was not their defense.
it was the lordship's order, my lord, that to see that whether he has not opted for the scheme, to produce any documents so that it can be proved from it that he has not opted for the scheme in 1971, my lord. We have a list, my lord, from the colliery.
Show us the document, that option page. Where is that?
Yes, my lord.
My lord, in this matter, Shiv Shankar Banerjee is engaged in court number 11 just now. This matter is going kindly make it possible, short possible.
Where is that document of option? Where is
Lord.
that provision towards option exercise?
Lord, in 71
Yes,
scheme, Lord,
71.
kindly have a look to. My lord,
71. No, not 71.
yes, there was a scheme in 1948.
85.
Page 80.
84 rather. This is the scheme of 98.
98,
71 scheme.
my lord,
Where is that? That he has to, you showed us na that specifically he has.
my lord,
Where
my
is that?
my lord, that was fairly given, my lord.
Uh-huh.
71 scheme, separately given.
70, we did not find it here. 71.
Yes.
It was handed over, my lord, it is not annexed with the petition, it was handed over late.
71 scheme, yes. This came in 71. Your engagement was 65.
67.
62, 67,
67.
67.
Your case was that you are not required to exercise option.
My lord,
You will automatically come under
Automatically.
98 scheme, and they made the deduction accepting you as an as an optee under the 98
my
scheme.
lord, my
That
lord,
was your case.
my lord.
But subsequently they have returned the money, stating they
They
have
say so.
mistakenly collected the
My
money.
lord,
You did not get the refund.
my lord, my lord.
Yes, show us.
Yes, my lord. My lord, I have folded the pages, my lord.
Yes.
My lord, in 71 scheme, if he has not opted for no, then he would have been included in the scheme. And if he had opted, yes, my lord.
put.
My lord,
5, my lord, is 5 is the thing, my lord. It says that N means no, and my lord, the not opted, and I folded the pages, my lord. This is the thing that was forwarded from the colliery to the respondents, my lord, to our office, my lord. And second page is, my lord, that
Please go slow. Let us.
yes, my lord. Sorry.
Where is Lilu's name?
My lord, in the next page, in the very next page, my lord, item number 117, my lord. 117. Lilu Mohato, Ram Mohato, son of Ram Mohato. N, my lord.
N has been tied.
Yes, my lord.
All.
No, my lord. N is first, my lord, in the first page.
But after the N,
Yes, my lord.
they
Those
put signature most more.
no, my lord. No, in the it was a list which was forwarded by the colliery, my lord. Colliery to the year that those person who have not opted for the scheme. It is that document, my lord, which has been forwarded to us by the colliery saying that this person has not opted for the scheme. So, my lord, the signature will not appear here because it is a document of the colliery. Initial list of roll of a coal mine.
Where is the not option? Because
My lord, not option is, my lord, in the first page, my lord. In the first page, 5, my lord.
Right in the
6, my lord. Write N against those who have opted not to join family pension scheme.
Copy.
Yes.
No copy was forwarded. My lord, they filed the affidavit.
No, my lord,
They
it is not-
used the affidavit in opposition. Nothing was disclosed.
My lord, it was a letter. We have stated in the affidavit in opposition that he
Rather-
was not a member of the 1971 scheme. So he was given a second option in 1988 that he also has not opted. But my lord, this document was not annexed to it.
we are not on the second option.
Yes, my lord.
Second option, if the first argument stands, then the second option.
Yes, my lord.
is validity.
Yes, my lord. But this is the
Issue to be considered is whether he was coming under the 71 scheme or not.
No, my
This is
lord.
the only issue.
yes. This is a document, my lord. We have able to
Then if he had not exercised option,
end, my lord.
so why did you make the deduction?
My lord, that was done by ECL, my lord, wrongfully, and afterwards, my lord, we have made the payment of those money which was accumulated with us, my lord. We have already made the payment, and we have also annexed it in our affidavit in opposition, my lord. The payment that was received by us with 8% interest, my lord. He has also received it. It was
Where is that?
yes, my lord. I am just, my lord, 1 minute, my lord. My lord, page 102 and 103, my lord. But an amount of 13 lakhs 96,358.
100 and
102, my lord.
yes. This was for which period? This is what is the amount you have given.
Yes, my lord. 2006 up to two.
This is only for the broken period.
It is, my lord, date of claim.
Kindly come at the top of this document.
Yes.
Refund made under para 63(1)(a). Where is the 63(1)(a) provision? Now, whose document is this? This is not your document. This is their document.
Yes, my lord, it is a document of the respondent number 8, Coal Mines Provident Fund Organization.
No, this list which you showed us,
Yeah.
this is the list of old members of Coal Mines Provident Fund.
Yes, my lord.
This list was sent to you.
Yes, my lord. By
Colliery.
by the Colliery, my lord.
When incorporating the remark N.
In, my lord. Yes. These are the persons who have not opted for the scheme, and in those persons, my lord, N was given. This is the list.
This is a random marking. How can we believe this?
My lord, it is an authenticated document from our from the respondents, my lord. That all.
Where is the authenticated document? This is just a list. Where is the forwarding letter?
The forwarding letter is there, my lord, in the first page.
To the learned advocate.
No,
No.
to the
Commissioner.
to the regional commissioner, my lord. Provident Fund.
That is you have said.
No, my lord, it was sent by to me, us, my lord, by Sri Amritnagar selected Colliery. My lord, 20.
Appearing for the Colliery.
No, I am appearing
Coal
for
Mines
respondent
Provident Fund
from,
Organization.
I am for under Coal Mines Provident Fund Organization, my lord. Respondent number 8.
I see.
I am the respondent number 8, my lord.
And who is for the Colliery?
My lord, Mr. Banerjee is for the Colliery. For the he is engaged in another court, my lord.
Okay,
My lord, if your lordship so directs, we can bring it on record by an way of supplementary affidavit, my lord.
No, সেটা হচ্ছে 98 scheme.
98 scheme আসতে চেয়েছে।
No, 98 scheme এও আসতে চাই।
71, my lord. It was sometimes in 71.
Opt for. We do not opt for this. কিন্তু এইটা ইমেটেরিয়াল হয়ে
এবার এইখানটা কেটে দিই চাই এর
হুম,
অফ
হুম।
পরে এখানটা কেটে দিই
এইটাকে ইমেটেরিয়াল স্কিমের মেম্বার থেকে 71 স্কিমে যদিও মেম্বার থেকে থাকে এই অপশনে কোনো নেই।
সেটাই।
My lord, if your lordship store address, you can bring it on record by a way of supplement. This is there, ma'am.
Briefta. I'm a puro briefta. Lordship, I have checked it. Lordship,
Wait,
puro briefta দাও দিন। পুরো brief। বাকি ব্রিফ কোথায়? আমার ব্রিফ কোথায়? লিঙ্গ তো ব্রিফ করো।
অপশনের তো রিকোয়ারমেন্টই পজ করতে হবে।
এটা আমাদের ব্রিফ। না,
Yes,
Lordship, I have thoroughly checked up. Lordship,
on what material you will make your submission? Before the read code, there was no material produced by.
Lordship, because this 71, he was not there, was the base of understanding for the court or for the councils. Lordship, then Lordship, I have to place in on record 2 documents.
Why should we allow you to place documents now at the appellate stage? Because more so when you deducted the money from him.
No, Lordship, that's what I'm saying. We have not deducted.
You're just now he said.
No, Lordship, probably is.
Affidavit, they have said that they have.
Yes, yes, yes. Please, I have not deducted.
Saying that you have not.
I have not deducted. Now my form 5 is also there. That's what I have brought the enter original statutory form. Now, Lordship, under 71 scheme, there are 2 parts. One is PF, Provident Fund part, and one is FP, Family Pension part, under Mines pension scheme. Thereafter, when the 98 scheme was proposed to be introduced, from the year 1/4/1989, irrespective of the fact whether he will go or whether he is in 71 scheme, 2% of the money is deducted. Previously, Lordship, if your Lordship knows, 1948, 8.33% was deducted for everyone. That enter money used to go to PF.
Yeah.
After 1948, under 1971, 1/16% goes to family pension. Rest of 8.33 goes to Provident Fund. And from 1/4/89, irrespective of the fact whether he will remain in family pension or not remain in family pension, 2% deducted. Now in 1998, which came into force from 1/4/1998, the calculation became 1.16 FP, means family pension, plus 2% of the PF scheme, FP scheme, that which we deducted, and 1 additional increment from 1/7/1995. This all fund transferred to 1998 scheme. But if someone who was not in 71 scheme and do not also give an option to including, he will get back his 2% with interest. So the deduction which your Lordship is looking into, that is only from 1/4/89 till he gives that form. So no deduction was made on FP, means family pension, as well as on this scheme. Now, I have a document to show that is called under statutory form, Form V inner. Each year I have scanned from 1972 to 1998. Here, Lordship will find we have not deducted the family pension fund all these years.
So this form was never called for. An original document I have also I can produce. I have retrieved those original file with all this member. So he was not in 1971.
All right. It shows that he had not opted under Regulation 4 of the OCD.
In
That's-
1998, he has not obtained lordship. We are getting it.
Clause 4. Clause 4.
Lordship. Now in clause 4, that form, I cannot have that form with me. That form will be with them. They have that form. They have find out. And with regard to my register, form V register, lordship, if I hand over this
That
one.
is your deduction.
No, it's a statutory register which I have to give it to them also.
What is your answer to this? That under clause 4, that if he does not want to join, he has. he shall
Right,
be
lordship, yes, there's no,
Where is the
that form I cannot have. That will be with the CPF authority. I am the company.
the CPF authority now only says that N not opted, finished.
No, you have form.
I have the list which I-
That is, you have given
Acha.
to the Provident Fund. This you are for Amit Nagar Colliery. You are appearing for who?
ECL, Eastern Coalfield Limited.
And who is, yes, under Eastern Coalfield, Amrit Nagar is under you.
Lordship, lordship.
So, Amrit Nagar has sent a letter.
It was a private colliery, then nationalized, lordship, from 1973.
You have scanned the documents, you have gone line by line.
Yes,
That's why we are saying
lordship.
that in spite of that, you did not find this letter, which was written by you to the Provident Fund Commission.
Lordship, that I could not, my record could not. And lordship, this is
We
the,
want to ascertain, see this document. This is a
Lordship.
communication made by you to the Provident Fund.
lordship. And this is the register form, lordship. Also, I'm handing.
Huh? Only.
A matter has been called on in court 19.
This you yourself sent.
Yes. Even if lordship, then lordship, we have to. So lordship, this,
But somewhat this is a new story in the at the appellate stage.
no, all along we said he was not in SEBI.
There was a deduction for affidavit. Today, in order to give you the benefit, we must have an opportunity to go through the documents. We were with you on the last occasion as
Right.
regards exercise of option, because you satisfied us that there was no such requirement. And their statement was that we will take instruction and come back with the records. Now they are, if you peruse that document,
Right.
which they will enclose in their opposition, saying that you specifically exercised option that I do not want to go to pension. Now, if your argument was that even if that is to be negated, court should give its verdict on the basis that there had been automatic deduction.
Right.
And
Right.
this refund you are saying that I have not taken.
No refund was made.
Now the statute under a specified form calls for a deduction which he is saying. We have not seen that. Now, if that is on record, Mr. Das, then you have to give a reply to that. Otherwise, in view of those documents, we just cannot now say that I will not allow it. This is the problem. Otherwise, how much gratuity did you get?
But 13 lakhs and odd was given a whole sum amount.
Along with the deductions and everything.
No specification, nothing.
I can give the check number by which that 2%.
So I can produce
That I
the
have.
bank passbook, my lord.
I will give the
before my
detail
lord.
of the check.
Mr. Das, they will give you all the records in the form of an affidavit.
My
In
lord.
reply, you bring those documents. Drawing our attention, clause 4 of the Coal Mines Family Pension Scheme,
Mota no,
1971.
Affidavit in reply.
Mr. Das, learned advocate appearing for the respondent stroke writ petitioner. Your
No,
appeal-
I was petitioner appellant.
Oh, you are the petitioner, sorry. Drawing our attention to such and such, Mr. Das, learned advocate appearing for the appellant submits that the appellant did not exercise any option not to join the said scheme. Mines Family Pension Scheme 71, in short, 1971 scheme. Not to join the 1971 scheme.
Just have a copy of
Join the 98 scheme.
Option then
ওটাতেও করেনি 98 করেনি
19 stop. The respondents accepted the petitioner as an optee of 90 as an optee of 71 scheme and deducted opting as a member of the 71 scheme and deducted where is that their opposition, Mr. Das?
My lord, is page 34. Relevant at page 37B.
And
The respondent accepted the petitioner as a member of the
71 scheme and 2% was deducted from the appellant's wages as an by way of pension. So, comma, as would be explicit from the averments made in the affidavit in opposition filed before the court. Mr. Banerjee and advocate appearing for the
coal company.
respondent number 2. No? You are for 2
Yes, Lord.
as well as the colliers.
2, 3,
who-
2, 3, 5, 6, 7.
Mr. Banerjee learned advocate appearing for the respondent numbers 2 to 7. However, submits that the appellant exercised option not to join the 1998 scheme.
My lord, may I just draw your lordship?
Let me finish, Michelle. Not to join 1998 scheme. Stop. There was also no, 91 scheme. Stop. Deductions from the 2% deduction was initially made by the authorities in terms of the provisions. You made the deduction that you are not sure.
Yes, yes. Deduction made and by check we have written. That deduction is made from 1/4/1989.
Further,
Made by the authorities in
submits that in
however submits that the evidence
2% deduction
optional,
Huh.
not to
From-
sign the 1990.
1998 scheme. 1998 scheme.
No, 9 from 1/4/1989 for 1998
We
scheme.
are not talking about not
Retrospective.
1998 scheme and praise for leave to file an affidavit in opposition to place the relevant documents on record. Yes, Mr. Das, what were you saying?
My lord, I was drawing your lordship's kind attention to page 54.
Yeah.
There's supplementary affidavit also.
Yes,
Kindly have a look.
deduction was made.
No, what they says, he was not the member of 1998 scheme.
Yes, yes.
Furthermore, by mistake, certain amount was deducted from the salary of the petitioner towards the pension initially and immediately after reduction. Due to such mistake, the same was refunded to the petitioner, a copy of such and such.
Yes, you have to, they will give you the document showing that you had not opted for the pension scheme. You reply to this they will be bringing on record.
Not if Mr. Banerjee says that it was deducted from 1989 at the prevalence of 1971 scheme. 1971 scheme was prevailing at that point of time. Not the latter on the 1998 scheme was introduced. Therefore, it was under 71
Or
scheme.
take instruction on this point. This is a document which shows
My
that
lord, my
you
lord,
not exercise option.
my lord.
You
Or not.
bring these documents on record
This and as well as by register.
because
And based on the file, and for clears the relevant documents.
And the document showing refund of 2%.
Yes, yes, Lordship.
there are further opportunities and stuff. করে দিয়েছিলাম। Stop. As the documents, comma, as placed, as the documents as placed before us by Mr. Banerjee, need to be put on record for adjudication of this, comma, we grant a further opportunity to the respondents to file an affidavit in opposition, enclosing all relevant documents, including the documents produced before us, Let such affidavit in opposition be filed within 2 weeks. Stop reply thereto if any be filed within a week after the vacation. Is the matter for final hearing in the daily supplementary list of report on 11th December.
No, would it be your lordship's pleasure to make it part heard? No, so that matter may be disposed of, since my lord have heard at length.
If the bench changes again, we have to sit.
No, kindly make it part heard. Kindly make it part heard.
Lordship, in this matter,
Not hard several times. Kindly make it part heard.
respondent number 8, Your Lordship, will appear before your Lordship. That name should be recorded. That you can file the affidavit in opposition.
ওখানে আরেকটা
You have already given the slip also.
এটা আরেকটা লাইন লিখে দাও ওনাদের নাম
দেবাশিস
দিয়ে
মিত্র,
দেবে
সবুজ
রেসপন্ডেন্ট নাম্বার the respondent number 8 would also be at liberty to file an affidavit in opposition within 2 weeks.
And you give the order as well as we shall communicate to my client also the proper instruction.
Order will be available today.
Um,
The matter is, keep it part heard.
ওই আগেরটা হচ্ছে as such we হ্যাঁ
Need to be
হুম
brought on record for a
হুম
knowledge.
we further opportunity to the respondent numbers 228 as well as the respondent number
27 and 8.
and the respondent number 5.
So kindly make it part, my lord, one.
The matter shall be treated as hardy part.
My, great.
Obliged.
Copy থাকবে 11ই ডিসেম্বর।
Appearing on the Union of India with dated by Sofik Nandi, the lordship was 6.
Where is Mr.
Yesterday,
Nandi? Where is Mr. Nandi?
he is engaged in court number, another court.
Huh?
He is engaged in another court matter.
Actually, he said we were about to pass the order.
Yes, yes.
Do you have anything more to submit?
No.
আসো অভিজি। The present petition has been prepared challenging an order dated 13 June 2023 passed in an original application being 350/01242/201 shown of unnecessary details. The facts are bullet as described. Mr. Mr. Tony Dunn for the lead petitioners to respondents. Submits that the engagement of substituting the railways. Yes, Mr. Nandi, you want to submit anything further?
But I have a little bit of submission, so kindly pardon me. 2 minutes. Yes. Before coming into it, 2-3 legal authorities, may I place facts from the order impugned and the findings of the learned tribunal, which was not at par with the directions given by this honorable division bench, the another coordinate bench. While the another coordinate bench remanded the matter back to the tribunal for adjudication afresh, taking into consideration the reason order. Reason order, that was not completely set aside by this honorable division bench while remanding back the matter, but the entire onus or the responsibility was given or casted upon the learned tribunal for adjudication afresh, taking into consideration the speaking order.
Page 115 see the record.
115, I'm on that, that's why I've come today. Second paragraph is relevant. The moment the court is satisfied that such application is made, the order of the tribunal cannot be sustained having passed solely on the fact that the representation was not made by the petitioner.
Just give
সেটা কি অস্বীকার করবে?
ওরা যেটা অস্বীকার করেছে সেই অর্ডারটা পেজ 90
And the documentation was so many times stipulated but rejected the application দুটো wrong day. Challenging the tribunal, application at the tribunal instead of going into the merit, proceed to dispose on the ground that no representation was filed by the petitioner in terms of the legal granted. Petition bench বললো এই অবজারভেশনটা ভুল কারণ আমি একটা সিল টিল দেখতে পেয়েছি অ্যাপ্লিকেশন করেছে হ্যাঁ ট্রাইব্যুনাল একে রিজেক্ট করেছিল যে on the ground that no representation was filed by the petitioner in terms of the liberty granted by the Supreme. তখন রেজিস্ট্রি করানো আমি
Submission is high court is not.
নোটিশ করেছে নোটিশ করেছে
Details are submitted separately. Other submissions need to meet an application of time on the matter which could be released to knowledge. Certainly partly to be very the only presentation
করেছে
করেছে application was made.
Right.
Now kindly come to the last 5 lines.
Last time, merely because
Yes.
that I also pointed out that merely because there is no policy of the engagement as on date.
That is your stand in the recent order.
Yes.
That it is bygone era.
Bygone era.
Next line.
The policy is existing on the date of submission of the applicant, that is 27th October 2005. Undisputed facts. That is for substitute in Group D post in Southeastern Railway in response to an invitations has to be seen. There is no denial on the part of the respondents that the advertisement was made in response to the general notifications. Proper procedure and codal formalities was followed in the matter of selection. It is also astonishing to note that the competent authority, while passing the impugned order, has not taken into consideration the holistic view which had been given by the Honorable Apex Court in record of proceedings dated 7/5/18, which has already been highlighted. So the second paragraph of the Supreme Court's order.
Come to that later. So the observation was their proper procedure and codal formalities were followed and application was submitted. So in the holistic view of the matter, you cannot now reject his claim saying that you received no rectification application from them. Why? Because of this reason, because the panel was prepared by you.
Lordship.
In the panel, you incorporated a wrong name. So having done so, you cannot today deny that I did not receive any application for rectification, Mr. Noti. How can you say so after 15 long years? Selection process held, participated, empaneled, but your stand was what? You are Prasanna, your name is Prashanto. But father is the same, address is the same. Today, Mr. Nandi, can you re-agitate this issue? Because the tribunal considered that. Now kindly come to what reply you gave in the right to information application made by
Yes, my lord. I
that
appreciate.
is that page you will find. Page 53, 54.
Page 72 and 4. 72 and 74. Kindly at first come to page 72.
72, yes.
Yes.
72.
See, Mr. Nandi.
No application, item 1. No application of Sri Prashant Kumar Das is available.
Available. Next.
No, since there is no applicant's name Sri Prashant Kumar Das, hence no appointment letter was issued. Next, Sri Prasanna Kumar Das did not file any application.
Now see the fourth one.
4. Biodata and documents of Sri Prasanna Kumar Das are found in the file and confirmed. Biodata.
Mr. Doti, you have to take a holistic. Don't have unnecessary facts are put.
But only 2, 3 judgments of Honorable Supreme Court consider. That is, delay defeats the equity. But that is my stand from the very beginning. Yes, my lord. Biodata had been provided by his father later on. 2007. No, my lord, at first kindly consider my lord, AIR 99 Supreme Court. For a moment.
Yes. AIR 99 Supreme Court.
Yes, my lord. Page 7. Not better. I'm referring from SCC. 1999 1 SCC 729. Only 1 or 2 paragraphs. 6. Go to these.
Delay defeat justice.
Delay defeats. Paragraph 6. May I read out? The applicants in a similar circumstances. Facts are almost same. This is Union of India versus Kishori Lal. The applicants submitted before us that with some justifications that in a writ petition which was filed in the year 1985, appointments which were made as far back as in the year 1974 ought not to have been disturbed if a similar relief is to be granted to all those who were in the merit list of 1974 of IAS and allied services examination and who were placed in class 2 post because of wrong notification of vacancies in the year 1974, there would be a complete disruptions in the posting and positions of the persons appointed as far back as in the year 1974, who were now occupying various posts, not merely in this department, but in other various allied services as well. The same would be the positions if the vacancies for any subsequent years from 1975 to 1990 are now recalculated, and the initial posting given to a large number of candidates during these years are now disturbed. They are undoubtedly right about this apprehension. Delay defeats equity in a known principles of jurisprudence. Delay of 15 and 20 years cannot be overlooked when an applicant before the court seeks equity. It is quite clear that the applicants for all these years had no legal right to any particular post. After more than 10 years, the process of selections and notification of the vacancies cannot be and ought not to be reopened in the interest of the proper functioning and morale of the service concerned. And it would be jeopardize the existing positions of every large number of members of the service. The respondents, however, submitted so and so. So therefore, this is the ratio as decided by the Honorable Supreme Court. And another point is 2006 Volume 1 SCC, page 779.
1 minute. প্রশান্ত দাসকে application করেছিল। প্রশান্ত দাস।
Only one paragraph. Paragraph 15.
No, প্রশান্ত দাস কোনো application টাইপগুলো করে। এবার ও 3 নম্বর লিখছে যে যেটা প্রসন্ন দাস যেটা ছিল অ্যাপ্লিকেশন করেছিল সেটা আমাকে ক্লিয়ার করছে। তখন হচ্ছে প্রসন্ন দাস কপি আছে কি স্যার?
No, sir, copy.
এটা আছে কি বলে অ্যাপ্লিকেশন
Yes.
2006 Volume 1 SCC, page 779. Paragraph 15 only. Assuming his names were figured in the merit list, whether he's in right of appointment on the point.
Right of appointment.
No right of appointment.
Para.
Paragraph 15. May I read out? Paragraph 15. Kindly come to paragraph 15.
Yes.
In this matter, the approach adopted by the Jharkhand High Court comments itself to us. The Jharkhand High Court approached the matter on the principle that judicial review is not available in such a matter. The Jharkhand High Court also rightly pointed out that mere inclusions of a candidate's name in the selection list give him no right. And if there was no right, there could be no occasions to maintain a writ petition for enforcement of a non-existing right. So, this is the principle of law.
Thank you, Mr.
But I did not reiterate the same point by citing so many decisions, but on the same line. And also, I rely on 2006, next point, 2006 Volume 3 SCC, page 330. Only one paragraph. Paragraph 14. Paragraph 14, only 4 lines. Selectees cannot claim the appointment as a matter of right. Mere inclusion of candidate's name in the list does not confer any right to be selected. Even some of the vacancies remained unfilled, and the candidates concerned cannot claim that they have been given a hostile discriminations. Well, this is our case also. After that, in 2013, this Honorable Court Division Bench of this in an addendum stage injuncted us not to fill up any post in the post of the substitutes. Okay, that post has been abolished. For the administrative exigencies, it was open. Now, railway authorities are in the process of regular appointment. So he timely he did not make any applications. Subsequently, after 6 years, made and took out applications. That was the views of the Honorable Supreme Court. Remanded back for limited purpose. Our division bench, this Honorable High Court has also said so. Remanded back the matter to the tribunal for adjudications only for a limited purpose, to the extent to find out whether he took out an application within the due time or not. So tribunal has not gone into even, not specifically dealt with this point of the Honorable Supreme Court as well as our division bench of this Honorable Court, and rather by influence by this honorable court's division bench order, my lord, straightway said, since the honorable high court said so, I am bound by that. I am allowing OA application.
All right.
But that is not decided, but should be set aside. This order should be set aside.
Yes.
This is my responsibility.
The argument of Mr. Noti that Prasanna did not submit any application for rectification of his name in the panel within the periods stipulated is not acceptable to this court. Inasmuch as the documents annexed at pages 37 to 58 of the petition clearly reveals that such rectification was submitted to the respondent number 4 on 9th November 2005. Stop. That's the next argument of Mr. Noti that the engagement of substitutes in the railways was a practice of the bygone era. And that such engagement is warranted cannot be accepted as a ground for rejection of Prasanna's claim, inasmuch as the Supreme Court had restricted such consideration. Bole dash dash diye dash kar. Mr. Noti further argues that the respondent did not file any application for rectification of his name during the year 2005 within the stipulated time in the year 2005. The issue has now been sought to be agitated by the respondent. Relatedly, about 16 years thereafter, belated is now agitated by the petitioner belated. Stop. Such belated application, such delay in filing the application, such delay in agitating the claim ought to have been considered by the learned tribunal. Stop. It is well settled that delay defeats equity and that inclusion of the name of an incumbent in a panel does not create any indefeasible right in his favor to be appointed. Stop. In support of such contention, Mr. Noti has placed reliance upon the judgments delivered in a judgment in 2006 volume 1, 2006 volume 1 FCC 779, Article 2006 volume 3 SCC 330, Article 1999 bracket close 1 SCC 720. Order passed next paragraph. The order passed by a coordinate bench of this court in the writ petition being WPC 470 of 2013, upon which reliance has been placed by Mr. Noti, was an interim order passed upon a prima facie satisfaction that the substitutes were being engaged at random without following any procedure. Then a tribunal duly considered the said order and found the same to be distinguishable. Upon considering the factual issues, the learned tribunal arrived at specific findings, and we do not find any infirmity in the same. Accordingly, the condition circumstance is dismissed. There shall, however, be. Yes, next. Yes, polytechnic was not included.
This one.
It is well known that the defense authority for what it decides, not what can be logically be deduced here. The judgments upon which reliance has been placed by Mr. Nandi. There is no dispute as regards the proposition of law in the judgments upon which reliance has been placed by Mr. Nandi. Stop. However, the said judgments are distinguishable on facts.
But I'm praying for a stay of the operations. Since my letter is dismissed by application, the whole
What
way allowed.
final application, read petition, you have been asked to give appointment there. Have you preferred any contempt?
No, my lord, sir.
Very.
Yes, next.
I'm appealing for that.
Lord, is this item number 8, your lordship, previously, Mr. Bag, senior advocate was appointed, but he has been changed because of the, lapse of the panel, and your lordship, it is a change brief which has come to me. There, I found that there is a copy of the affidavit in opposition affirmed, said to be affirmed. But actually, I have not found that, and I have also searched the records of your lordship, where I find that there no affidavit has been filed.
So what you are praying for adjournment?
No, not adjournment. I was praying for your lordship leave to file affidavit in opposition.
After so many years,
After-
Mr. Mishra.
My lord, 10 years, my lord. After 10
10
years.
years?
10 years.
You,
Kindly see, sir. My lord, your lordship, on the last occasion, asked me to obtain a affidavit of their affidavit, supplementary affidavit filed in CAT, administrative tribunal. I have collected
no,
that.
in CAT, their affidavit.
The supplementary, your lordship.
The question is, your lordship, what I found is that in the CAT also the thing is that those documents were not there. But the question is that as far as the judgment is in our favor of the CAT, and it is a case of suppression and or false statement made at the time of appointment, and on that basis, under Rule 5.
You will consider that. What is your prayer today?
What is your prayer?
If your lordship kindly grants me leave to file affidavit, I may be given.
Did they file opposition before the tribunal?
Yes, yes.
Yes,
And
yes.
they constructed.
Stands upon that.
Yeah.
Please.
All right, your
You,
lordship.
You have
on the,
copy
on
of
the,
that?
Yes.
You have a copy of
Yes,
that?
I have copy.
That opposition had brought on record.
yes, yes, my lord. My lord, on the last occasion, my lord, your lordship asked me to find a affidavit producing documents of the government of India, Union of India.
To page 59, your opposition is there, annex,
In before your lordship.
but
No.
only pleadings.
It is in the CAT.
Chat,
In the CAT there, that I accept your lordship. I have gone there.
but only-
This is also there. I have got it. You don't give me. I have got it. In that, your lordship, what my learned friend had produced today, we have only submitted the papers which the Honorable CAT has asked us to produce.
No. You filed a reply, gave a reply.
We have filed our reply under Rule 12. Also there, that is there on the record. In the CAT record.
Then what new affidavit you will file, Mr. Mishra?
The question is, your lordship, that thereafter the representation, after that, there was, in the meantime, there was an order of the Honorable Cat that we should reconsider, we consider their representation, we considered the representation, and thereafter the representation was considered and it was rejected. And thereafter we have filed our, we have issued termination or letter, and they have thereafter filed this writ petition.
How can that? Original application was disposed of in 2013.
13, and
So-
prior to that in 2009, your lords, there was an order of in
So
2009,
that was challenged in the before the tribunal.
before the tribunal, not here.
Yes. So that was the subject matter of the original.
Yes, and that also has been passed. Thereafter, from 2016, he has been from that 2012, he has been terminated. Then there is no question of any status quo or anything there. There was no injunction also in the matter from the
What
from,
injunction will be passed? Termination. You have terminated his service.
yes.
Yes, place the case.
Yes, Lordship. Lordship, your Lordship kindly point the judgment of the tribunal, my lord. On the last but one page, my lord. Should I read, my lord, paragraph 7?
Please give us
Lordship.
5 minutes time. Let us
Lord-
go through. Yes.
Lordship. My Lordship, my case, in short, my case is, my lord, I was appointed as a probationer in a specific grade, and I was holding a civil post. The verification report received from the district magistrate antecedent was found in order. There is no defect in it. The verification report, my lords. And there was some apprehension. District magistrate cast a doubt about apprehension of my previous from my schooling from 1 to 8. The qualification required is class 8 passed mark. That part is in order, my lord. They did not find it anything about the last transfer certificate, my lord.
First tell us, what did you challenge in the earlier original application? 950?
950.
There was an earlier paragraph 5 of the impugned judgment.
Let's see. That's I gave you. That
Was the you challenged in that original application. When was your order of termination?
order of termination, may not.
You have challenged 30th May, 9th April, 7 July, 21st July.
May I submit, my lord? Termination has been passed only once, and it is at page 23, my lord. It is page 23, 23. No, sorry.
The report is here on record.
Lordship.
The district magistrate report is
Lordship,
here.
all reports is there, my lord. My lord.
First show us your termination order.
Lordship.
Page 23, first
No,
August.
no more. Page 51, sorry, my lord.
You were appointed on August 2008.
Lordship. I have prepared a short list and relevant dates. Should I give? Yes.
Then after the order passed in the tribunal application, earlier tribunal application,
Lordship,
your termination was 7 July 2009.
Lordship,
You challenged that before the tribunal.
Lordship,
Tribunal said direct to consider and dispose of the representation of annexure A5.
Lordship.
What is that representation date? 30th June 2009.
June.
যেটা ট্রাইব্যুনাল A5 30th মে আছে, ওটা তো সুপার 30th জুন বললো কেন? দেখো পেজ 50 করে after that order
Lordship,
of tribunal, after that order of the tribunal at page
representation to section. Lordship. Representation.
Page 52.
page 52 was the earlier order of tribunal.
Lordship,
After being declared very reported. Now, by order of 7 July, your service was terminated.
Lordship,
Then you challenge this. Okay, now kindly come to paragraph 4. Therefore, in the direct respondent number 2, be considered and dispose it of.
Lordship,
Now, where is that order? Where is that order, Mr.
Lordship,
চার সাথে ছাড়া
The supplementary affidavit which you have filed,
Lordship,
where is this last page of the order? The supplementary affidavit which you showed us.
it is the Union of India, my lord. Subject.
There you have a copy.
Yes, yes, ma'am.
Take that copy. Annexure 1. This is the 20th August.
Lordship,
Got it?
Lordship.
Where is the second page of this order?
Second page is not annexed, my lord. I have collected it from the registry of the tribunal on the direction of your lordship on the last week.
Then what is
Because they have not produced it before the court. Your lordship asked them to produce it before this court, honorable court. And that's why I approached the tribunal and I obtained the certified copy in this form, my lord.
Oh.
They did not produce it before your lordship. That's why I intervene, my lord. It is a original certified copy, my lord.
Yes, where is the order, Mr. Mishra?
Lord, that is, the order has not been, that was, I was submitting before your lordship, that order has not been annexed with the writ petition. And the affidavit over here is not there on our behalf. So I wanted, that is why I wanted that the lordship kindly grants me leave to file, and I will say, submit that copy of the order along with that affidavit. This was my submission before it on that document, because they have not annexed. And I have got the copy.
What he will do, you people are sleeping. He is out of service. Agony is his.
So, your lordship, I can show your lordship.
What he will show? Where is the order passed? Do you have the order passed after the tribunal's direction?
After the order of the tribunal order that we should consider his representation. That order.
That no. Your order is there. When did you pass that order?
So the only thing, my lord, may I apologize because the thing it is marked. So your lordship.
Doesn't matter. What is the date of that order?
The date of order is 20th August 2009.
That is, do you have the last page also?
Yeah.
Do you have the complete
Last page.
order?
Yes, both the pages are there. The back page and the first page and second page.
Yes, show us.
That's why I'm submitting. On the back side, that is the second page, your lordship.
Yes, so what is the wrong with the order?
My lord.
Have you brought rule 5?
Yes, I had.
So to tell us what
CCS temporary service rules, my lord.
5-1.
পুরো রুলটাই দিয়েছি। I'm reading they have terminated my service applying rule 5. What rule 5 says, my lord? Do not use any words if it means a simple citer. But they have done this. The foundation is they issue a show cause notice. They made an inquiry on my back. What is the matter about, my lord? I applied for the job. I have selected through the process of law. And I have placed in a scale of pay. After the district magistrate sent my verification report, they found me in order. There is no wrong in it. My last school leaving certificate was in order. There is no wrong in it. They have appointed me. And I have served for 1 year. But in the district magistrate order, my lord, your lordship kindly come to page, my lord. That is a 43, my lord. 43. Should I read, my lord?
Yes.
It is the verification report. The undersigned returns the attestation form.
First come to your verification form.
Verification form.
Who verification form you file?
My lord, verification form is not annexed, my lord.
Yes, it is annexed.
Yes.
Your verification form which you filled up, that is at page 28.
28. No, it is a medical, it is for my medical certificate under section 49. It is not there. Short word, a short word, apprehension, that cost my job entirely. And I was kept out of my service for last 14 years.
Read page 43.
Lordship. I am reading, my lord. The undersigned returns the attestation form after verification of his character and antecedents and informs that there is no adverse report against the candidate in the South Chobbish Parganas district.
Wait. No. Yes.
I stop here. This is the original report that they wanted. Verification, when a person is appointed, a verification is done by the district magistrate through intelligence branch or something else.
Or
That
antecedent.
Lordship.
Now
But
read the portion.
Lordship, I have
As per
my humble submission, I have an objection of this portion because that is handwriting interpolation manner. Handwriting interpolation notes mailers. What I have read, it is a type portion. It is, I am reading mailor. As per IB report, identity of nationality of the VR subject have been verified and found correct. He passed class 6 and his date of birth is on something 1974 as per school record. During inquiry, it is apprehended that the VR subject got admission at Hotar Adorsho High School at class 8-7 on the strength of fake transfer certificate, etc. However, the primary level study class 4 passed in the subject from Rotua Biraj Mohini Junior Basic School has been verified, and as per school record, his date of birth is 16 March 1974. It is not a apprehension, my lord. It is not a verification. It is apprehension. There is no inquiry. There is no inquiry, my lord.
You first took admission in the primary level.
Lordship.
That is in the school of Ratna Biraj Mohim.
Lordship.
In that school, your date of birth was recorded as 16th of March 1974.
Lordship.
After that, you took admission in the Hotar Adorsho Junior High School.
My lord.
On the strength of some certificate.
Lordship.
Now, in that school registered, your date of birth was recorded as 84.
But my lord, they have made correspondence with that schools, the authority responding. I'm placed here before your lordship. The school authority firstly confirmed that the fellow is myself. Later they issued a correspondence letter to the authorities that father's name is late and the student's father they are referred to is late. He's not in like. It is a stigmatic matter. No inference matter. My humble submission is whether my school certificate is false.
Mr. Niyogi class, please assist us.
No, Lord.
Your first admission was in which school? Tell us. When did you take first admission and in which school? Tell us. Your first admission was at Ratno Biraj Mohini Junior Basic School.
I'm taking instruction.
You will take instruction now.
What I'm submitting, my lord, I have taken instruction. I have last.
Mr. Niyogi, you filed a verification report at the time of appointment.
Lordship.
In verification and appointment, there is a clause that if you give any false information, that will be
Lordship. Lordship.
Now, on the basis of your verification, police undertakes an investigation.
Lordship.
That is not a investigation behind your back. That is the procedural layout.
Lordship.
To ascertain the veracity of your statement.
Lordship.
Police conducted. IB report was that your initial admission was in a particular school where your date of birth was 1974.
Lordship.
So if that was your initial admission, Mr. Niyogi, you now cannot say that that is a wrong incorporation in the record. How can you say?
My lord,
That is when you took admission in another school, in Hotar Adarsha Vidyalaya, you must have relied upon some document to show that your date of birth is a 1984. Then the school authorities incorporated in Hotar that it is 80. How can you come out of this?
my lord, in this writ petition, I have annexed all these documents where I've read.
You
There-
you show us the Ratno Biraj Mohini certificate.
Lordship, I've Hmm?
স্কুলের কবে ছেড়েছে দেখ 3 দিনের 2 দিনের জন্য দেখাচ্ছে পাতা তার হচ্ছে
Your lordship kindly come to page 40, my lord, 40,
First come to page
What?
31.
31.
This is which school? This is Hotar Adarsha.
Lordship,
So here your date of birth is 84.
lordship.
Sorry. Now kindly come to where is the certificate? ওইটা কোথায়? এই যে এটা
Another, your lordship kindly come to page 39, my lord. 39.
39 হ্যাঁ
Yes. It is a দক্ষিণ চব্বিশ প্রাথমিক বিদ্যালয় সংসদ.
You got admitted in the hospital on 30th April 97 and you left the school on 2nd May 97.
Lordship,
Admit for 2 days.
lordship,
2 days.
lordship,
You are in that school.
lordship.
Ah.
দক্ষিণ চব্বিশ পরগনা জেলা প্রাথমিক
প্রাথমিক বিদ্যালয় এটা ওর কাছ থেকে ইয়ে করেছে।
শংসাপত্র।
হ্যাঁ এই ইংরেজির নামে এই পর্যন্ত নথিভুক্ত আছে আপনাদের পার্থের নাম এই 2 তারিখে সেই ইয়ে
এটা কোন স্কুলের? এটা তো প্রাথমিক স্কুল।
এটা কামরত্ন এটা দিস ইজ হুইচ স্কুল
স্কুল না, এটা দক্ষিণ জেলা প্রাথমিক বিদ্যালয় সংসদ।
সংসদ ইয়েস হ্যাঁ প্রধান ভারপ্রাপ্ত শিক্ষক
বিকজ প্রাইমারি স্কুলে তো প্রাইমারি স্কুলের ডিসচার্জ সার্টিফিকেটটা তো এরা দেয়। ইংরেজির 30/4/97 পর্যন্ত যে ছাত্রছাত্রী হিসেবে নথিভুক্ত আছে।
এই যে রত্ন বিরাজে
ওটাই চাই
বলছে 17/3/1974
কোথায় পেলেন?
এটা হচ্ছে ডিএম এর বক্তব্য
হ্যাঁ সেটা তো কি, কিন্তু এই রত্ন বিরাজ মোহিনী জুনিয়র বেসিক স্কুলের ডকুমেন্টটা কোথায়?
অ্যানেক্স করে
Where is that document, Mr. Niyogi?
Lordship,
That
রত্নবিরাজ
Ratno Biraj
স্কুল সমাপদ পাত্র
হবে addition।
ইয়ে করেছে পরপরই
এটা হচ্ছে হোতার আদর্শ বিদ্যালয়ে he took admission reading in class 8 in 2001-2002।
will your lordship kindly come to page 34, my lord. মৌখালী গোপীনাথপুর গৌরবালা বিদ্যালয়. Thirty-four, my lord, please.
Moukhali said that there was no such student in your name.
Yes.
They relied on, they make correspondence with the Moukhali Gopinathpur Guru.
Mr. Niyogi,
Lordship.
kindly come to where is Biraj Mohini certificate?
Biraj Mohini.
Where is your transfer certificate from Ratna Biraj Mohini?
না, মধ্যে নেই, মধ্যে।
No, not. Yes.
মধ্যে নেই।
Within 1 year, you got promotion in 2 class. First and 7 in the year. Come to page 39.
39. Lordship.
You left the school on 2nd May 1997.
Lordship.
Then come to page 55.
Yes. Panchkula High School.
Yes. In 1998-9, you are reading in class 6.
Lordship.
That is within 1 year you read in 2 class, 5 and 6.
But he left in 1997 and he read in 2 years, 1998 and 1999. For 2 years, my lord, for 2 classes.
Is 1 year only, 1988.
No, not it is not meant a financial year. No, 2 years. It is not a financial year.
6 classes only.
No,
for
you are
1
not
year, not 2 years.
not accounting a income tax year, financial.
Is it page 39 টা তুমি page 39 টা হচ্ছে রত্ন বিএম অবৈতনিক প্রাথমিক স্কুল যেটা এখানে বলছে। যেটাই বলেছে সেইখানে বলছে 84 ডেট অফ বার্থ।
Date of birth.
এখানে সেটা বলছে কি বলেছে
Certificate কিন্তু স্কুলে তারা
70
দেখেছে I think.
has been verified and as per school record date of birth is 16th of March 70. এখানে তো check
হচ্ছে স্কুল রেকর্ডিং সার্টিফিকেট, হচ্ছে স্কুল রেকর্ডিং দেখেছে।
school record. Acha, where is the district magistrate
Lordship.
order, Mr. Niyogi?
Lordship, it is 43, page 43, my lord.
Class 6. মৌখালিটা পেয়েছো?
এইখানে Where is Mokhali?
Moukhali.
না এটা হচ্ছে পাঁচুয়াখালী। Have you got admitted in any school bearing the name Mokhali? We are also not there. 97 you are in class 4, 98 class 6, then 2002 class 8. In class 4 you Ratno Biraj. Class 6 you Pachuakhali. Class 8 you Hota.
In 7, he admitted in class 7, my lord. He admitted in class 7, my
In
lord.
which class?
Hota,
Hota.
7. Hota.
Hota, yes.
Last school he read. That was in order, my lord. There is no dispute about that. Last school, my lord.
He was reading in class 8 in 2001, 2002.
Lordship.
So what is the reason for leaving? Abolition of school, closure of school.
Previous school was closed, my lord.
Before
Lord,
closure,
my humble submission, my lord, there is dispute, my lord.
How can we give the benefit when there is a dispute?
My lord, my humble submission is they district magistrate apprehended such mistakes is there. Some serious thing is there. They have to inquire into. And what should have been done. They have made a so-called notice to me. They have made so-called notice on the fundamental of this. They terminated me. They did not give me a chance to give my place the records all before the authority.
Did not reply to the show.
Yes, I have replied it.
That was considered. Showcase
What?
was considered
No.
when 7 July order was passed,
Lordship,
which you challenged in the earlier petition.
Lordship. But
You are in probation. Your conduct has to be assessed by the employee. They have not held any inquiry behind your back. It is the usual procedure.
my humble submission is entire inquiry they made with the school authorities instead of asking me. They should have initiated departmental proceeding against me. For such and
But
dismiss.
they will ask you in the verification form which you filled up,
Lordship.
you gave your date of birth as 1984.
Yes, absolutely.
So to check that, date of birth, the DM has conducted an inquiry. What is the wrong in that? That is the procedure.
My lord, that verification was found right. There is no wrong in it. But DM was confused and apprehended. DM is apprehended. There is no concrete against me. There is no inquiry report against me that I have done such and such. There is confusion. They should have.
what DM apprehended?
They
That
apprehend.
you got admitted in Hota school on the basis of a
Correct.
transfer certificate. And on the basis of his such apprehension, he checked and verified the school record.
Lordship.
Of which school? Ratno Biraj Mohini School, junior basic. Ratna Biraj junior basic school.
Lordship.
Then from the school record, you find that your date of birth was 16 March 1974. And the certificate issued by the Sangsad is fake.
My lord, 74 is the date of birth of another student whose father, who is similar to the applicant, petitioner, and his father's name is deferred. That's why they made a correspondence with the school authorities, and the school authorities later it is issued a corrigendum. That fact was not asked by me, by them. I have not given a chance to reciprocate all these things, my lord. Had they given me a chance, a departmental proceeding initiated, what I am entitled to, my lord. My lord, Anuj Joshua says, my lord,
Where is, what is the infraction of the rules, tell us?
infraction of the rules, my lord. Your lordship, kindly come to page rule 5, my lord.
Yes.
I am reading, my lord. Termination of temporary service. The service of a temporary government servant shall be liable to be termination at any time by notice in writing given either by the government servant to the appointing authority or by the appointing authority to the government servant. B. The period of such notice shall be 1 month, provided that the services of any such government servant may be
The relevant portion. Which portion has been violated?
lordship. My lord, your lordship come to rule 2, my lord, 5(2), sub 2, in the middle order, in the middle order.
Mhm.
It says,
Where you are saying?
page 2, my lord.
Page 2.
No, page 2, no, my lord, it is rule 5 continuing, my lord.
Yes.
Not mention the
2, sub rule 2, my lord. 2. Your lordship finds
Yes.
when the action is taken as under rule 5 to terminate the service of a temporary employee, the order of termination, which should be passed by the appointing authority, should not mention the reason for such termination. That I'm relying on that paragraph alone, my lord. And I have precedents, my lord, of the Honorable Supreme Court in favor of me, my lord. Kindly consider, my lord. Lots of precedents, my lord. Supreme Court specifically says my lord, I am admitting they could have terminated my service without saying anything. I have nothing to say, but they have made they stigmatized my service. They have, for this I have not been appointed anywhere. I have not got a job anywhere, my lord. They in the termination they stigmatized that I have done these things without any inquiry. That's why I'm before your lordship, my lords. It is a case of stigmatization, my lord. It is not a simple citer, what they have placed before the administrative.
The final order passed by the authorities.
Lordship.
20th August 2009.
Lordship.
You don't have the copy.
Lordship.
This is the copy we have been given. Do you
I-
have a copy of this?
Yes, I have.
No, the second page is missing.
Second page is missing. Sir, একটু দেবেন আপনারটা। জসে পড়তে বলছি। এটা এই সেকেন্ড পেজটা যেটা স্যারকে পড়ে জসে পড়ে শোনা হচ্ছে।
আমি ফাইলটা তো স্যার অনারেবল কোর্টকে দিয়ে দিয়েছি আবার।
আচ্ছা।
I have already given.
আচ্ছা, সরি।
Already given.
Copy them. Give a copy, Mr. Mishra.
I don't have that. That is the only copy your lordship gave. I have.
Xerox of this and where is the application?
This has been recently, I mean, day before yesterday, this has been given to me by the department. That thing I have received. The question is the order has been passed under rule 5(1). Rule 5 subsection 1. My learned friend is referring to. The question is that it is clear that if there is any false information is given and any fake thing is produced or any suppression has been made, is liable to be terminated or any further action can be taken.
Stigmatifies allegation.
My lord, my lord, I have number of judgments, my lord. If your lordship kindly allow me.
The judgment will come later. You must see the order.
Lordship.
Unless you see the order, what you will argue?
Lordship.
Records reveal that pursuant to the earlier order passed in records reveal that in the earlier round of litigation, the learned tribunal in OA OA 950 of 2009 directed the respondent number 2 or any other competent authority to consider and dispose of the applicant's representation. Mr. Mishro, learned advocate appearing for the respondent, submits that pursuant to the said order passed by the learned tribunal, the competent authority passed an order on 20th August 2009. He prays for leave to bring the said order on record by filing an affidavit in opposition. Let such affidavit in opposition be filed within 2 weeks. Reply thereto, if any, be filed within a week after the vacation. List the matter as per orders in the daily supplementary list of this court on
Lordship,
on 7th December. So, the matter shall be treated as harding part.
Lordship, under compelling circumstances, Lordship,
May I take that papers?
এইটা petitioner এর
একটাই document
তাহলে ওই প্রেস ফর লিড
I have got a bunch.
প্রেস ফর
Bunch.
কি বলে প্রেস ফর লিড that order you want to bring on record or there are other documents?
You know, the thing is that IFLCB, I have seen.
Other bring on record said order and other relevant documents. You bring your all documents by way of an opposition. এইটা ওনাকে বুঝতে
Lordship,
Yes.
under compelling circumstances, Lordship, I am mentioning one appeal. It was before Justice Velumani's court earlier. Then, Lordship, this was not listed. There was a direction, appeal was admitted. Because tomorrow is the contempt proceeding, Lordship, the officer is facing a contempt proceeding.
What were you are sleeping?
Paper book was directed, paper book is prepared, now handed over, paper book is handed over to the. Lordship, the only thing is that, Lordship, can it be listed, included in the list of hearing, because it was supposed to come in June.
But that will be listed in the combined list, Mr. Judge. On 9th, the list will be coming out.
Lordship, may I hand over that? Not on ninth.
Please, you please survey notice and remind us tomorrow morning.
Lordship,
Direct it to appeal.
New motion
for inclusion,
This is not the time for mentioning. Is this the time? New motion, when did you file?
last week.
grateful, my lord.
Last order. Judgment.
In our considered opinion, the learned single judge has rightly directed reinstatement of Sukhdev in service in the post of constable at the stage from where he was dismissed / discharged from his employment, and such direction is affirmed. However, we are unable to agree with the direction towards payment of full back wages with all consequential benefits to the Sukhdev. It is well settled that reinstatement and the payment of back wages are two independent issues, and an order of reinstatement does not mean that the person would automatically become entitled to back wages. In the facts and circumstances of the case, such direction towards payment of full back wages with other consequential benefits to Sukhdev is not sustainable and is accordingly set aside. However, the appellant shall grant notional benefit, including pay fixation and seniority to Sukhdev for the period from when he was dismissed / discharged till the date of his reinstatement. With this observation and direction, the appeal and the connected application are disposed.
Very good. Grateful. Your lordship saved life, my lord. Otherwise,
He is laughing because he doesn't have to pay now. Yes.
very good. Grateful.
Item number 7.
But I beg to appear on behalf of the appellant, on behalf of the respondent. The lordship was kind enough to allow us to file exception to the report of the executive engineer, Kolkata Municipal Corporation, on the last occasion, my lord.
Oh, that municipality.
Municipality, yes, my lord.
Mr.
This is-
Mukherjee is appearing, Tanmoy Mukherjee is appearing for the appellate, my lord.
Very
He's engaged in code number 19. If your lordship kindly pass it over, my lord. Sir.
In that case, my lord, not today, my lord.
No, not today. All right. Not today.
Tomorrow at 2 p.m., my lord.
Everything cannot be as per your wish.
No, my lord, cannot be. Certainly not, my lord.
Chalo, 2 p.m. করে দাও।
Deeply
My
obliged.
lord, my lord.
Yes.
আর কোনো 2 p.m. নেই তো? দেখলে খুব ভালো। দেখতে পাবো।
I mean, I'm for the respondent. Really.
My lord, in this matter, I am for the petitioners, my lord.
What compassionate appointment?
My lord, this is the matter, my lord. My lord, we succeeded in the, my lord, departmental, my lord, selection process. And thereafter, ad hoc promotion is given to the petitioners, my lord, in the year 1980, my lord.
And thereafter, from that time, my lord, they were appointed as the my lord ADM post. And thereafter, it was converted to the junior engineer. They continued for 27 years or more, my lord. Now, my lord, they have been transferred to the, actually ad hoc appointment was given to the, in the, my lord, construction department of the railways. They were, initially they were appointed as the, my lord, casual workers, my lord, in the open line.
They exchanged affidavits.
No, my lord. Affidavit is necessary because of that, my lord. Some important point is that these persons, my lord, they have been deprived from their getting their, my lord, dues, my lord, for which they did for my lord, lordship.
Said that there is no necessity for exchange of
My lord, because of that, in the my lord, in the order, in the at point of time, my lord was opined that, my lord, since my lord, it was the, my lord,
documents are on record.
my lord.
But the other matter, losses, I have got 20 days. But PM, we fixed it 2 PM, but 2 PM tomorrow we have original set.
Oh.
So we are keeping it at 12 noon. You intimate the others.
Yes, Lord. I
All, intimate all.
all I am intimate all.
Your other side.
Watch out.
But point is,
My lord,
If you find them, you can ask them to come before this court so that we can tell them. You give a ring to Mr. Vishwas and Mr. and ask them to come to us before rising so that we can.
my lord.
point is very
Now,
simple.
no, my lord, point is very point.
On the last
Point is not
occasion-
at all, my lord. It is simple.
On the last
It's
occasion,
a-
my lord
it's a
was
matter
free
of,
to
my lord,
direct the railway authorities to come with the calculations. My lord, my point was, our stance was that the Lordship Tribunal was pleased to direct the these petitioners to make an application representation before the authority for considerations regarding promotions. They are seeking promotion
my lord.
to the ad hoc post, but the promotions they are seeking the ad hoc post. It is not possible because promotion is a controlling by a cadre that is with regard to the main post, that is the original post. So we have made the calculation. On the last occasion, I also submitted. Copy has also been served upon my learned friend. My lord was pleased to direct my learned friend to come with instructions whether our stand was they would be much more benefited.
My
So
lord,
for financial aspects is concerned, if they make this representation before the appropriate authority in compliance of the tribunal's order. So that would be, it's a very clear, simple calculation. All the applicants had already been retired from the service excepting one. So now what maximum benefit they would get? After retirement, only notional benefit. So better they are, it appears from short calculations, so far they will be financially gainer if they accept this proposal of the railway authority. Now it is up
my
to
lord,
them.
since 1997, my lord, up to my lord 215, my lord. Several representations were made to the authorities, my lord, for reverting back the petitioners and to give the, my lord, original promotion in the open line. But they did not, my lord.
We will consider for promotion. We will consider Mr. Saha.
My lord, now, my lord, question of my lord, making application, my lord. Because of that, your lordship kindly consider the, my lord, impugned judgment, my lord, passed by the, my lord, tribunal. My lord, your lordships considered the same, my lord. Wherein, my lord, it is specifically they have in the, my lord, the tribunal, my lord, directed us, my lord, liberty was given to the applicants to make an application. Application they made, my lord, long back, my lord. Long back in the year since 2097, my lord. My lord.
Suppose the tribunal would have asked them to come and tell their stand. That tribunal could have done instead
my lord, in the earlier occasion.
Taken a decision.
My lord, in the earlier occasion, my lord, tribunal, this was the second time application before the tribunal. If your lordship come to, my lord, I have taken, my lord, kindly see, this is the, my lord, this is their, my lord, comparative statement of monetary benefit to only one Mr. my lord, the Devashish Banerjee, ADM. who is the, my lord, applicant number 4 here, my lord, in this writ application. My lord,
You're appearing for all.
all, my lord.
Since all other retired.
My lord, now, my lord, we are not at all satisfied with this one, my lord. Because of that, they did the work. What they, my lord, kindly read the, my lord. What?
When you continue to suffer, what can?
My lord, that is why, my lord, I have come before your lordships, my lord, because of the deprivation of the petitioners, my lord, for long back, my lord, since to 27 years, my lord, they are suffering. Your lordship.
You get the notional benefits. They are not saying you will give all consequential notional benefits.
All notional benefits.
Only if you could have got regular promotion, the actual salary, the difference which you are claiming, that you will not get.
Yes.
Apart from that,
My lord, we did, my lord, we did, my lord, the work of the junior engineer lastly. And my lord, it was continued since 1990, my lord. Now, my lord, what we are getting, my lord, we are getting the payment of, my lord, only 2,400 in spite, my lord, instead of, my lord, 4,200. We are getting much less, my lord.
After vacation,
Very well.
Lordship.
after vacation,
It's a, my lord, it's a question of, my lord, deprivation of the, my lord, applicants for long time. If your lordship kindly.
next date, okay, monthly combined list, monthly combined list of December. No, November, we will be combined.
Kindly, my lord, if your lordships.
তারপরে 3 দশে পেয়েছে না এইটা হলো শুরু হচ্ছে and I
Kindly keep it on record. Well, this is instructions, written instructions I have received. So far, the one petitioner is concerned. So this is very clear calculation made. They got 3 jump they had given.
They have given it. It is not that you have showed any blessings to them. When there was no person in the, my lord, department, they, my lord, in a recruitment process, they recruited us.
Mr. Nandi Learned Advocate appearing for the respondents has placed before us.
had it been handed over to you.
Lordship, it has been given. If your lordship say, my lord,
এই তো বোঝালাম,
Yeah, take instruction. What will be the beneficial?
my lord, I have
understanding what we are saying. We are asking you that yes, you will not get the consequence, you will not get the actual salary.
lordship.
Today you are aged persons, you have all retired.
My lord, one of the
Please listen
my
to
lord,
us.
my lord,
Please listen to us.
my lord,
You are all aged persons, you have all retired. 7 except 1.
lordship.
Now today, if the litigation proceeds,
Then what
will be beneficial?
Yeah, I am also your lordship is
You
right.
get notional benefits, you will get all because your pension will be enhanced. You are getting pension.
Yes,
Your
yes.
pension will be enhanced. You
Only
will be a new scale. Or you, if you don't do that, we pass our necessary orders upon hearing. What can be done? You cannot.
We also
Oh,
cannot
on
insist.
You also cannot. It is for your clients to decide. You also cannot insist upon your client.
My lord,
You comply with this. But please apply your mind.
my lord, kindly fix it after vacation. I shall come, my lord.
Please apply your mind.
My lord,
You are aged.
my lord,
persons.
I
Life
have,
is uncertain.
my lord,
You have a family. Today you are getting 100 rupees pension. Calculate the consequential refixation of pension. You suppose you have retired getting a pay scale of 10 to 100.
my lord,
Today, if the consequential benefits are given to you with pay fixation from the date of your entry, because they are giving it from 1990. 1990 they are giving.
my lord.
Kindly understand where your pay fixation will come to. Today we are in 2023. You must have retired in 2020 onwards.
Lordship.
Kindly appreciate.
My lord.
Then the scale gets enhanced from 10 to 100 to maybe 500 to 1000.
My lord, kindly, my lord, fix it next week, my lord. Then this matter may be.
This is the Nandi Learned Advocate
Lordship, কি বলবো বুঝতে পারি?
appearing for the respondents has placed before us.
আদারওয়াইজ সেইভাবে সন্ধ্যা করা যাচ্ছে
Documents pertaining
ঠিক আছে
grant of financial upgradation.
তাহলে অর্ডার করি
Stop. Let me say document
But we keep
financial upgrade.
Financial comparison chart of the financial.
No, this memo which you have annexed, this is relating to grant of financial upgradation.
Financial
Under
upgradation.
MSc.
Yes, MSc.
You will give the benefit with notional.
Notional.
This is your.
If yes. And for super promotional aspects is concerned, the cadre controlling authority is there. Let them go back to them, make their representation.
Kept on record. Stop. Copies of the same have been handed over to Mr. Shaha, learned advocate appearing for the petitioners in court today. You praise Mr. Shaha prays for an accommodation to avail necessary instruction. Is the matter for further consideration. Detail is supplementary this court. 12th December. 12th December. You make up your
My
mind.
lord.
If they are not agreeable, then you argue on merit, prepare a list of dates and finish off your argument.
Lordship.
On 12th, we have fixed.
On 12th, my lord.
12th of December.
Yeah.
Yes.
Yeah, much.
Deeply honest.
Mr. Nandi, wait, they are all retired persons. Let us keep it even earlier date.
But already they had given three promotional additional. Prior to their due date, they got it.
Mr. Shah, it will be on 29th November. All right.
Deeply obliged.
We fail to understand why they are not accepting our proposal. Say financially they'll be gainer.
Yes.
They got three promotion millers at the same time.
They will be financially gained if you give the actual cash.
I shall try.
Give actual benefit, not notional.
Not notional.
That actual cash matters, na?
Right. Actual cash matters.
Does not help.
So subject to or availability to me. If I get, then I'll share.
No, you see that you are given debit cards.
Right.
Now somebody uses your debit cards, you did not feel the pain
Right.
because cash is not going.
Right.
Yeah. The bank account will come.
Right. Well, it will be debited from there. Yes.
Yes.
My lord, I'm for the petitioner, my lord.
Wait, please. My lord, I
My lord, this matter,
wait for the response.
my lord, in this case, the respondent appellant has filed OA application before the learned tribunal, Central Administrative Tribunal, my lord. And there, the learned tribunal was pleased to pass an order of injunction, my lord. Interim order was passed on 5/8/2021, my lord. The order is there, my lord. So, my lord, by virtue of this interim, I am here, my lord, only to expedite that matter pending before the learned tribunal below. Because, my lord, the interim order was passed on 5/8/2021.
Where is that order?
My lord, I have annexed
What?
last page. Original one is also there. Original order is there and the last annexes.
You have annexed an order of 23rd of August.
No matter the main order, the original order is also annexed.
Where is that?
5/8/2021, my lord.
The last part, 2 pages.
second last page.
Here, my lord, the learned tribunal is that hard learned counsel for both sides were satisfied with the quality of audio or video during hearing because it was during the COVID period. It is evident that notice dated 5/10/2020 has fructified into a seniority list where the applicants have been placed above DR quota. Learned counsel for the respondent should clarify in terms of notice dated 5/10/2020 that if IS quota, in-service quota, that is in-service quota filled up by notification dated 17/10/2017 have to be placed above the direct recruitment quota and selected against the notification dated 16/1/2018 and 9/3/2019. The reason as to why the applicants who have been selected against the in-service quota are not being allowed to appear for the trade test for the promotion to the post of technician grade 2. Next, any trade test conducted today, that is on that date itself, in violation of notice dated 5/10/2020 shall abide by the result of these OA and the persons so allowed to compete shall not gain any seniority above the applicants in the event we find that the notice dated 5/10/2020 has been violated. Let the result of the trade test not be published till the next date of hearing or listing. Respondents shall also indicate whether the representation of the applicants against the new seniority list dated 5/1/2021 has been disposed of prior to the finalization of the seniority list and consequent conduct of the trade test. Let the matter be listed on 23/8/2021. This was the order, my lord. By virtue of this order, my lord, the trade test
Belong to the in-service quota.
Yes, in-service quota, but there are two provisions, my lord, that the persons who belong to in-service quota, they have to.
Now, after this, what happened?
But after this, my lord, the result on the day itself, state test was held, but the result was kept pending.
Participated.
Yes, yes, it's kept pending, my lord. Thereafter, there several dates are gone, my lord. Next day, 23rd/8/2021.
When did you have filed any vacating application?
Yes, my lord, that is there, my lord. I've annexed that document, my lord. It is page.
So, interim order, when did you file the vacating application?
It was filed on 11/10/2021.
Where do we get it?
My this is page 38, one annexure P5. MA 534 of 2021. Because, my lord, on 23rd August 2021, when the matter came up, the learned tribunal was pleased to direct to file an application for vacating the interim order. So I had filed this application 23rd/8/2021. The order first passed. Page is page 49. Here that my lord, learned tribunal was pleased to direct.
Page. Let us get the page.
Yes, sir.
You are appearing for the appellants.
They are, my lord, for the respondents, because
You are for the
opposite respondent.
you are for the respondent.
There, man. Here I am for the petitioner.
Now this was 23rd of August.
Yes, my lord.
When did you file it?
11/10/2021. The same day, same year. It is written.
2021.
Yes, my lord. Thereafter, my lord, the next date was 5/10/2021. Next page, my lord. Page 50.
So you have served this copy upon all the applicants?
Yes, my lord. Let rejoinder be filed in the matter during the course of this week.
Have you served upon the?
Yes, my lord. They are happy. They are also appearing, my lord.
Your service?
Today is there, my lord.
You are appearing for whom?
But I am appearing for the original application.
Original applicant.
Yes, respondent
Who
here.
is appearing for Union of India? Nobody.
They are appearing for the Union of India. They are
the private
Here,
respondents.
no, they are not the private respondent.
I am not the private respondent, my lord. We are
They
the.
did not make the private respondent a party here as well.
He did not make the private.
Because, my lord, Union of India.
You just now said, sir, that you are the private respondent.
No, my lord, you are the respondents over there, my lord. But the applicants who had applied in the trade.
Union of India.
Yes, Union of India.
You made, apart from you, all the parties to this petition.
Yes, all the parties who have filed the OA application, we have made them party as respondent.
Exclude the remaining. You will exclude the remaining.
No, my lord, because they have made this OA application, so they have been made respondent party.
You will still argue. Where is your original application? Do you have that original application?
Yes, my lord, I have.
But for the
original applicants.
They have been made party. And
We are the opposite
private,
party.
and the private respondents have not been included.
My lord, what happens here during this interregnum, my lord, I actually also, my lord, did not make them parties. So, my lord, they themselves, my lord, filed addition of party application. It was allowed. Now they are parties in the before the learned tribunal.
Yes.
So, my lord, they ought to have been made a party because now they are private
Where is
respondents.
that order of addition of party?
My lord, 31st of August 2021. If I can take your lordship, my lord, the page I'll tell you, lordship.
How many persons were added?
My lord, subject to correction, my lord, 13.
19.
30.
1-3. I'm not, my lord,
19.
Total number of persons were 19, my lord, in this application.
private respondent.
Right? Where is that order of addition of party?
My lord, it is 31st of August's order, which my learned friend, my lord, has.
1st August 2021.
Yes, my lord. 31st of August 2021. But it is not, if I can take your lordship, page number would be.
No, page 40 is that.
Correction করে না, একটু give দিয়ে দাও।
Page 50 ছিল joint debit.
31st August, yes, 31st August, SK Dotto filed application for
Addition of party.
addition of party respondents allowed. Yes, sir. Kindly come to page 50.
Page 50.
Yes, my lord. Yes, my lord. Hard learned counsel on both sides. Let the joint debit filed in the matter during the course of this week. And leaves the matter on 22/11/20.
They have been added as party to the original application. You have to file, you have to implement them. You have to check up. This order is there on record. If there had been 1 or 2 persons, we would have given you liberty. Withdraw file afresh.
But my lord, only one thing, my lord, in this case, we are praying only to expedite the matter that is to the pending before the original tribunal, my lord.
How can we pass that if all the parties?
Because my lord, only that is hampering because the entire administrative process, because
Sir, we are asking
yes,
you
but-
know that, but you are.
but as per the instruction, then my lord, to liberty to withdraw and to file a
We are helping you. You are.
Yes, yes, my lord. তাদেরকে অ্যাড করে তাদেরকে তো নিতে হবে এই কজনের ঘর দিয়ে যাদেরকে অ্যাড করেছে তাদেরকে তো নিতে হবে সেটা তো দেয়নি কিছু কত দিয়েছিল
ডিপার্টমেন্টের কাছে থাকে।
Now, that application was allowed, they were incorporated in the cost title. What is your procedure in
But
office corrects the cost title?
my lord, office does, subject to correction, my lord. I'll be confirmed once I, my lord, talk to my learned friend, my lord, who was representing the original applicants over there. But it is, my lord, my lord, the procedure over there that the office does the correction once the applications are allowed.
Yes,
Same
office will do this.
will be doing that. And similarly, that has been done. What happens here, afterwards, my lord, with the other orders, your lordship will be seeing that the private respondents have been taking time for filing the rejoinders. So this is why this matter, my lord, we have been regularly, my lord, appearing, and my learned friend will be agreeing with me, I'm sure. Yes. From the record itself, that 22 dates we appear.
Have to bring them. In their presence, order will be passed not to give unnecessary adjournment.
No, my lord, subject to correction, my lord, because hard landed counsel for both the sides, because whether they are private
They were there,
respondents
they were there.
are asking for time, that is not there. But both the parties are suffering because, my lord, this is interim order, my lord.
Check up and tell us.
No, 27th February order, 27th February 2023, lordship sees the order. There it reveals that the pleadings is not completed because the private respondent did not file the return yet. It is 2023, which is at page number 63.
We could not get the instructions, so.
They are represented all the time. Lordship sees.
But my lord, in the original
Appearing
application,
for petitioner submits upon instruction. On the prayer of the learned advocate appearing for the petitioners, present application is dismissed as withdrawn with liberty to file afresh.
Great.
Petitioners দেখে নেয়।
So I am for the writ petitioner, my lord. Which on previous occasion, lordship directed me to file my affidavit in reply. So I am filing my affidavit in reply. I have served upon my other side also. My lord, this
The in opposition. এইটা কেটে দাও।
Is the other side.
Sure.
Side. Your other side.
My Mr. Kollan Chakraborty, my lord, he was there and when the matter was taken up on the last occasion. Lordship, he used one affidavit in opposition over which your lordships granted me liberty to use a reply. Lordship, I have served a copy of the reply upon my other side long back and he has received it. Now, my lord, this is a matter.
Any urgency, Mr. Rai?
There are urgency, my lord. This is a very unfortunate petition. Is a very indigent person, my lord. Petitioner applied for the post of Banglo peon. He was appointed in the Banglo peon. Now he has discharged his duty in that capacity for 8 months. Thereafter, what happened, my lord? The person with whom he was attached, he was transferred to Kolkata. Now, in Calcutta, my lord, there is no sanctioned post of Banglo peon. Accordingly, his service was discharged. Now, thereafter, my lord, petitioner made a representation before the appropriate authority so that his name can be maintained in the roster. Because there is a provision to that extent in the Chief Personal Officer's office order, under which he was appointed as a Banglo peon, that a person who has rendered more than 120 days of service, if his service is satisfactory, then in that case, his name will be maintained in the roster so that in future, if any contingency so arises, he will be taken back in service in some other persons or followed by screening and then regular absorption in Group D. That is a circular, mind. Thereafter, representation was not considered. I filed one application before the tribunal. Tribunal directed the authority to consider it. That was rejected. Now, my lord, challenging that, my lord, I prefer this original application and the impugned order I have appended here, which is a subject matter of challenge.
Rejected on what ground?
Lordship, my lord.
Rejected on what ground?
On this ground that I have no right to be, my name should not be there in the roster because of the circular. But however, the circular is very much there, and it says in no uncertain term that even if I am discharged after rendering 120 days of service, but less than 300 of service, then my name should be maintained. But if my service is terminated due to my lordship unsatisfactory work, then it's they have the liberty to struck my name out. But so far as the roster is concerned, my lord, kindly see the termination letter, which I have appended at page 33A. It's not a stigmatic termination, my lord. It's a termination because there is no sanctioned post in Calcutta. And the rules are very much there. I have appended the rules, which is at page 44, 11, page 45A.
First was the order by which your claim was rejected, against which you
In this
went up
case, my
to
lord, appearing for the Union of India, I am praying for not today.
Where is he?
He is busy in court number 8. He is engaging.
Could you kindly come to page 33A?
Come tomorrow. Tomorrow.
Tomorrow.
Okay, affidavit in reply may be kept with the record. Reply.
ওই রিপ্লাইটা দিয়ে দাও। Give it tomorrow, we shall.
I have served upon my other side. It's a very innocuous prayer, my lord. I am not asking any job or appointment or regularization. Only my name to be maintained in the roster as per the railway board policy. That is my case.
Come tomorrow. Yes, next.
রিপ্লাইটা কি রাখবেন না ওদের ডাইরেকশন রিপ্লাই যেটা আপনার কাছে থাকবে তো ডাইরেকশন এটা দাঁড়াও এখন কল করবো আমি সরি
Item number 12 is fixed for on Friday, Lordship.
On
Item number 12 is fixed on Friday, Lordship.
Friday,
Yes, Lordship.
13th.
12.
13 my lord after the petition.
No, no, not item number 30.
Oh, I'm sorry.
Item number, sorry, ওটাই বলছি, item number 12 wrongly appeared in the list. Yes, Lordship. Much obliged.
That's clear.
In item number 10, may I file the affidavit service, my lord? In item number 10, that was with your lordship allowed to withdraw. Affidavit service, if you can.
You know, service filed by the petition.
কথা বলে না
Affidavit of service filed by the petitioners be kept on record. ওই লাইনটা অ্যাড করে ওটা কত আইটেম ছিল? Which was your item, sir?
Item number 10.
10 এ ওটা দিয়ে। Yes, 13. Item 14, ever 14.
My lord, 13 my lord arm for the petition.
13.
Affidavit of service to me.
You served, Mr. Rai.
My lord, I have served already. Sir, আপনি কি আছেন? But I
It's your other side.
affidavit,
But affidavit of service is ready.
but, my affidavit of service is not ready. But though, my lord, it is my mistake, my lord, but the matter was very urgent because it was, anyways, I could not produce. It is with respect to subsistence allowance. সেটা কোথায়?
Complete service and come.
আমাদের বাড়িতে আগে কোনোদিনও হয়নি। My lord, lordship will, this is the first time I'm appearing, my lord. I am told that it is submitted to your lordship's record. But I am not sure because it should not be because it's for the first time appearing to my lord.
এই record
No, my lord. I'll check and I'll check,
my
madam. No.
বলছে যে
I'll check, my lord. Sorry, my lord.
ফ্রাইডে রেখে দাও।
Great football.
Yes, next.
কোনোদিন আর আগে হয়নি।
I am preparing for the petition.
But I appear for the respondents.
Affidavit service টা দিয়ে রাখেন। কয়েকটা আছে। Previously on my original application before the tribunal, the tribunal directed to consider promotion and if I am found fit and to give all consequential benefits. This term, all consequential benefit, was not, my lord, excluded by any particular benefits. All consequential benefits includes Anything wrong with me, my lord?
Carry on. We are giving you applause that the way you are arguing. Anyway. We were not about you, we were talking about another matter.
My lord, if your lordship kindly turn to first, my lord, page
No,
30.
Mr. Said we didn't follow. The first original application said considered your claim
If your lordship kindly turn to page 35.
of the order.
Yes.
Order impugned.
No, not on order implement. I'll come later. I'll come later, my lord. Because it is the base on which, my lord, my lord, contention in the last or
Yes, page 35.
here. Excellent.
In connection with the above selection, the service records, working reports and ACRs for the last 3 years in favor of the following, sir, may kindly be sent to by
My lord.
yes. This is what you are placing, Mr. Sir.
No, my lord, page 50.
আবার বলেন।
Page 50.
Page 50.
50. Operating part at page 55. Page 55. May I place it, madam, for your lordship's convenience? Considering the facts of the case and on perusal of records, we are prima facie satisfied that the impugned rejection order dated 15/3/2010 does not sustain and the same is liable to be quashed. Accordingly, it is quashed. The respondents are directed to constitute a selection committee and consider the case of the applicant for promotion to the next higher grade from the date his junior was given promotion with all consequential benefits, plural. These, my lord, all consequential benefits does not expressly exclude any of the consequential benefits. Why I am coming later. It includes all. My lord, these
Then what happened?
order attained finality. They acted upon that. But how they acted upon, you'll also kindly see at page 62, the order. Page 62. In obedience to the Honorable Calcutta Bench Order dated 26/6/2012, which I have placed before Lordship, passed in way number so and so, Senior Digital Assistant Loco SRC, in the scale so and so, presently working as Loco Pilot, goods so and so, is hereby promoted to the post of Loco Pilot, goods diesel, grade 2, in the scale of rupees 5,000 to 8,000 RSRP on promotion basis, on pro forma basis, from the date of promotion of his next junior Sri M. Papara, Senior Diesel Assistant Loco.
Effect from 28 July.
28th July.
Now tell us.
And I'm coming with.
No.
Yes.
How is the you were working as Loco Pilot goods?
Yes.
What was your scale there? You were promoted to Loco Pilot goods in the
Yes.
scale of 5,000 to 800.
8,000.
Sorry, 8,000.
8,000. With effect from 28th July 2004, that is from the date of, and my lord, with effect from 28th July 2004 is the actual benefits, actual promotion from the date of taking over the charge from of the said post up to 8/9/2010. And the actual basis from the date of shouldering the higher responsibility. Yes. Your lordship is correct. I'm wrong. From 28th July pro forma basis, 20th July 2004. And from 8/9 to till 8/9 2010, and from the next date, that is 9/9 2010, actual basis, that is the date of shouldering the higher responsibility.
LP goods is a post above the post of loco pilot. Were given loco pilot scale on notional basis up to 8th of September 2010
Yes.
from 28th July 2004.
Yes.
And actual basis for shouldering higher responsibility of the post of LP goods.
From 9/9 2010.
That has nothing to do with this matter.
I'm telling you, Lord. My Lord,
John. So you are in fact wanting the actual
benefits from
2004 to 2000.
from 28/7/2004 to 8/9 2010. Actual benefit. Because they cannot deprive me of the promotional benefit insofar as pay is concerned.
You were promoted from which post?
My Lord, senior assistant.
Cell assistant loco.
Yes.
You were in the scale of 4,000 to 600.
Yes, my Lord. 4,000 to 6,000.
So, loco pilot goods under
Senior assistant loco pilot. That was the post.
Promoted to the post.
4,000, 6,000 scale.
To the post of loco pilot goods.
5,000, 8,000 scale. From the date his junior super. Actually. Yes.
But I have challenged that.
What did the
First part I have challenged.
What did the tribunal say?
Tribunal said, considered two judgments. One judgment of 2006 of the Honorable Supreme Court, where it has been said that as per paragraph 2. Yes. This is 29th May 2023. I have not paginated one. 8 minutes. May I start from paragraph 6?
Give us 2 minutes.
Fine.
Have you brought on record the IREM?
Yes. I am handing it to your lordship.
So what is the scope of any interim order, Mr. Sen? This has to
Right
be
now,
heard.
yes.
There is
My
no
lord,
scope.
only thing, my lord, they have relied upon year 2006, not 2006 Supreme Court judgment. And I have relied upon 2007 judgment of Supreme Court of equal strength.
Yes, Mr. Roy, you can finish it up or
Lord, I do not know whether reply and rejoinder was exchanged before the tribunal.
Everything is annexed with the WPC, this petition. Reply rejoinder was exchanged between the parties. I have annexed all.
you have annexed.
Therefore, there is no scope, subject to correction. There is no scope for any affidavit for
I find
further
that
development of factual aspect.
all the documents are not legible. Anyway, Lord, I shall just ask for a copy from my learned friend.
So it is a
Now,
point.
who has given you authority to modify the order of the tribunal?
Lord, it has never been modified. If your lordship kindly have a look.
Tribunal has said you give him promotion from the date his next junior promoted to the
That's
with
correct, Lord.
all consequential benefits.
Right, right. Lord, I just
While going to
I
comply
just-
with the said order, you part that give him pro forma promotion for this period, give him pro forma promotion sub. Whether that liberty was given to you.
no, Lord, kindly see the first order of the tribunal, where the consequential benefits was directed to be given to the petitioner.
Without giving any liberty to interpret the expression
no,
consequential benefit
Question
to
of
your officer.
the question of selection was there. Your lordship has seen the order passed by the tribunal in the first round of litigation, where there was a direction to constitute a selection committee because his ACRs were never upgraded. And Lord, he did not actually work. The question which is required to be decided by your lordship, whether he was given the actual promotion and he held the post. If he did not hold the post, well, the question of salary.
That Mr. Roy,
Yes, Lord.
suppose a person is dismissed from service.
Right,
He is reinstated.
right.
Now, upon reinstatement, whether back wages will be granted. or not. In that case, Supreme Court says,
Yes, Lord.
when you have not discharged service,
Yes.
you cannot claim as a matter of right.
That's
that
correct,
give me
Lord.
back wages.
Yes.
And Supreme Court also interpreted whether seniority comes with inconsequential benefits or not. So Supreme Court held that seniority will not come with inconsequential benefits, as you are arguing.
Yes.
And that seniority is subject to fulfillment of certain conditions,
Right.
ACR remarks,
Yes.
performance, etc.
Yes.
But in this case, tribunal has said that if you find he has been superseded, to give him promotion from the date the junior was promoted with all consequential benefits. Now, whether you can interpret that consequential basis by borrowing some railway circular which you did not feel it proper to challenge before the High Court. You could have challenged that order, that this order requires clarification.
Yeah. No, Lord, my humble submission before your lordship is this, Lord, that the tribunal never said in the first round of litigation that he should be given promotion. The tribunal said that you constitute a selection committee if he is found to be suitable for promotion. Yes, Lord. Page Lord, 55, operative part, which has been shown to your lordship by my learned friend. But I am just reading, Lord, in my own way. Considering the facts of the case and on perusal of the records, we are prima facie satisfied that the impugned rejection order dated 15th March 2010 does not sustain and the same is liable to be quashed. Accordingly, it is quashed. The respondents are directed to constitute the selection committee and consider the case of the applicant for promotion to the next higher grade from the date his junior was given promotion with all consequential benefits. The same shall be done within such and such time. Now, Lord, this was the order. So constitute a committee, selection committee, and consider the case of now, Lord,
you come to page 46, 47.
Right.
In page 47, by issuing a memo dated 15th March 2010, you denied his promotion on the ground that he was graded average in the ACR of 2001 to
Right.
2002-3 and 2003-4.
Right.
That memo was set aside by the tribunal.
Right. That memo is set aside.
Yes.
That memo is
Tribunal has not said that you sent it to the authority, that he will again check whether average is proper or not, whether it can be upgraded to good or any other benchmark.
right.
That is not.
No, this
That's set aside.
this was set aside with a further direction upon the respondent to constitute a
Yes,
selection.
adopted a procedure that you give it by appointing a selection committee.
So we'll kindly see the date. We'll kindly see the date of cancellation. We'll kindly see the date of rejection of
15th March 2020.
Selection. And
Consider the case of paying for promotion to one is junior. From
See,
the date his junior was given to board.
with all considered, তাহলে consider
Consider half good.
consider যেহেতু consider করার logical
President. Consider করলে এই প্রমোশন ওই যে to the next এবার উইথের কাছে এসে এবার
consideration
সেটা সিলেকশন কমিটি কনসিডার করে।
also be corrected in service. Just to be honest. Mr. Sen,
My lord,
kindly come to page 55.
55.
Let us read together.
My lord.
Respondents are directed to constitute the selection committee and consider.
Yes.
So they were asked to consider.
Yes.
What to consider? That case of the applicant for promotion to the post of next higher grade from the date of his senior was given promotion. One part. Consideration of one part was giving promotion from the date his junior was given. And the second part is with all consequential benefits. That their argument is that we considered, but
Okay.
as you have not discharged service during that period,
I'm telling.
you have to.
My lord, this second part,
Eh.
to give promotion with all consequential benefits, it is to be read with the first one. If I am found,
Junior. If your junior has super.
if a junior has been given promotion, if it is found and I am entitled to promotion, then I will be given promotion from the date my junior was given promotion, from the date. That has been given. Now the later part, consequential benefits.
It's also to be considered, Mr. Sen. Suppose today I ask you, Mr. Sen, you consider two aspects. That whether you can give me promotion from that date and whether you can give me consequential benefits.
Well, the second part is dependent on the first part. When I my lord go through, I am through on the through the first part, then my lord automatically consequential benefits will follow.
You can here read the Supreme Court judgments.
Not only point that which requires to be decided by
As
your
it was-
lordship,
IRDA
whether
is on record, Mr. Sen.
No, it is not on record. I have brought it. I have also brought the book and Xerox copy with me.
So you please do one thing. You file a supplementary affidavit enclosing the IRDM. and
May I
the
please,
judgment
may I submit
So
it to
you
your
have
lordship?
already got it.
Yes, I've got it. I've got it. IRM 228. Instead of, my lord.
Hardly learned advocates appearing for the respective parties and consider. Hardly learned advocates appearing for the respective stuff. You have been informed that
My lord, kindly consider that petitioner, my lord, had already retired from service in September. September 2018. September 2018. So your lordship may kindly keep in mind regarding expediting September 2018.
you want to, Mr. Rai, you don't want to use any opposition.
Lord, I want to use.
About
আবার কিসের opposition? Just তো বলছে কিসের opposition? Reply rejoinder হয়ে গেছে তো।
Lord, if reply and rejoinder, Lord, is already, yes. In that case, Lord, I shall only, Lord, make my submission with supported by Supreme Court judgment that if anyone did not hold the post, he is not entitled to salary for that post.
You argue that.
Yes,
What
Lord.
is the
Your Lordship,
basis
Covered by Supreme Court judgment. If I have not at fault.
that you can place before us.
Yes, that is the only point, Lord, whether he is, yes.
You need not file any opposition.
Supreme Court judgment, you will file through epidemic. No, Lord, in my brief, Lord, what is troubling me, Lord, in my brief, Lord, reply and rejoinder, I was not fine. That's why I was saying. Illegible, I don't oppose. Illegible.
Oh, illegible. সেটা তোমাদের ডকুমেন্ট আমার নয়। Illegible গুলো তোমাদের।
All right. I don't oppose all these things.
He finds difficulty, give a copy.
If anything wanted from him, I must supply to him.
All right.
I must supply.
He has been informed that the petition was decided upon exchange
Of reply rejoinder.
That the original application was decided upon exchange of affidavits and the pleadings and documents are all the pleadings and documents are on record.
Yes.
Thereof, is the matter for final hearing in the daily supplementary list of this court on 29th November.
29th November.
I'm extremely grateful to him.
Grateful to your lordship.
But only question, Lord, I shall try to convince your lordship whether without holding the post, he can claim the salary for the post.
Reserve. That has been answered by Supreme Court in 2007.
Upon hearing the learned advocates appearing for the respective parties and considering the materials on record, we are of the opinion there is no scope towards issuance of any interim order. Stop. Next, we have been informed that the original application was heard by the learned tribunal upon exchange of affidavit.
Reply rejoinder.
Original application was decided by the learned tribunal upon exchange of affidavits. Stop. The pleadings and documents. All the pleadings and documents are already on record. And all the pleadings and documents are already on record. In view thereof, list the matter for final hearing in the daily supplementary list on 29th November.
Yes. I'm extremely grateful.
You place the judgments?
Yes. Judgment.
Actually, there is no dispute.
No. Only question of law.
My lords, in item number 15, I'm appearing on behalf of the petition. I'm led by Mr. Orpo Chakraborty. Lordship, I've served upon the respondents, but the service has not yet been effected, Lordship. I was humbly praying for not this spec.
The learned advocate appearing for the petitioner submits that service upon all the respondents are not complete. In view thereof, list the matter for further consideration on 9th October, 10th October. The petitioner is directed to complete service in the meantime.
Great.
My lord, item number 16, my lord, pertaining to Bonosha Act's case, my lord. The new cases, my lord, I have the leave to appeal and I have a condemnation.
But item number 16 to 19 are analogous matters.
Analog
16 to
19.
my lord.
But they are leave to appeals.
Leave to appeals are there.
But the other matters are fixed for final hearing on 9th of October at 2 p.m.
Well, 17, my lord, I am appearing. 17, I am
16
This
is
is
my
the earlier order, my lord, passed in the analogous matters, my lord. Wherein, my lord, your lordship has been pleased to fix the matter on 9th.
No, what are the applications before us?
But these are leave to
leave to
appeals.
appeals and my lord, I have a condemnation of a delay application for 14 days, my lord.
Where is your application? Leave to appeal.
My lord, 10-2, my lord.
আছে এখানে?
হুম।
কোথায় গো? অ্যাপ্লিকেশন তো নেই।
In all the matter can 2. 16 only can 2.
17 also, my lord, can 1.
Can 1.
Can 1 leave to appeal.
Because my lord, in 16 can 1 is the section 5 application, there is a delay of only 14 days.
Let the application. এই শুনুন, ওই আগের we have been informed কি বলেছে? We have been informed that the original application was decided by the current right now. Upon exchange of affidavit. Upon exchange of reply and rejoin.
সেগুলোকে জোগাড় করে এখানে
Stop all the pleadings and documents. Stop all the pleadings and documents are already on record. Stop. তারপর in view thereof. Affidavit না করে reply rejoin. হ্যাঁ, পেয়েছো অ্যাপ্লিকেশনটা?
এই স্যারের নাম
স্যার বলে
হবে কিনা অর্ডার দেখি 17 করে দিয়েছে
হয়তো সাহেব চলে যাবে।
হ্যাঁ 17
হ্যাঁ, অর্ডারটা বলে দিচ্ছি, তুমি অ্যাপ্লিকেশনটা আনলে সই করে ছাড়বা।
Let's take it. 16, first 16, keep 16.
16, my lord, this is the section 5 application and can 2 is the leave to appeal. So I have only 14 days and this is my affidavit of service, my lord.
Can 1 and can 2 still নেই। ষোলোটার আছে, হ্যাঁ। What is can 3 then?
Stay application, ma'am.
Stay application.
Yes, ma'am.
Delay of 14 days.
14 days, my lord.
I 14.
In your stay application, did you file affidavits in the other matters?
No, my lord, not required. But actually, what happened, my lord, before the learned single judge, my lord, 32 dates were there, but wherein 4 reports were called for from the state. Exchange of affidavits were there. My lord, they were not made a party. That was the only allegation in this appeal, my lord. Affidavits were not called for.
Oh, affidavits were also not called for?
No, no, by this bench, my lord.
Oh, আচ্ছা, আচ্ছা। 9 তারিখে চাই।
No, 9 তারিখে যাও।
9 তারিখে affidavit চাই। আসো।
A paperwork has been filed, my lord. They have been exchanged also. They They have served the paperwork. Not in this, but the mailed files are there.
No, we will allow the
Yes.
leave to appeal and we will fix the stay application along with the stay application for final hearing along with those.
Yes.
matters. The paper book will be same paper.
Yes.
No?
My lord, may I file the affidavit of service, my lord?
Affidavit of service filed by the applicants be kept on record. An advocate appearing for the applicant submits that the applicants participated in the selection process for appointment to the post of Bono Sahayoks. Upon emerging to be successful in the said selection process, they were impaneled and appointed. They were impaneled and appointed.
Since 2020.
Stop. They are working in the appointed. They are working in the said post since
2020.
2020. Stop. Which paragraph stated? He further submits that in the month of, when did you come?
No, I don't have my copy.
The copy.
Okay.
Tell us.
Key. কোথায় হলো? My lord, order dated May 2023. My lord, we get the copy. My lord, after that.
Thereafter, in the month of, he further submits that in the month of May 20, in the month of June 2020.
20, man. It has been affirmed in the month of June.
Thereafter, in the month of May 2023, they came to learn that the selection process was challenged by some unsuccessful candidates.
Yes.
And the said writ petition was heard on merits.
Yes.
And disposed of in their absence, setting aside the entire
selection.
Right, so?
Yes, madam.
They stop. According to him, according to him,
there was no
intentional
latches.
No. In the said conspectus, the applicants are disposal. The applicants were not made parties and they had been the worst sufferers since the selection process itself has been cancelled.
Well, cancelled and new selection process has been notified. My lord, that has been.
Stop.
You
are for whom?
Writ petitioners. Writ petitioners.
Mr. Learned advocate appearing for the writ petitioners respondents disputes the contention of the applicants, denies and disputes the contention of the applicants. Stop. Who is for this? Mr. Tapabrata, learned advocate appearing for the state. Enters appearance on behalf of the state and submits that after cancellation of the said selection process, a new notification was issued. But in other appeals preferred by selected candidates, the operation of the new notification has been stayed. Upon hearing the learned advocates appearing for the respective parties and considering the materials on record, we are satisfied with the explanation given towards the delay in filing the application for leave to appeal. Stop. Such delay is condoned and the application being can such and such is disposed of. It further appears in stop as the applicants were the successful candidates. They ought to have been impeded as the applicants were successful candidates, and as the selection process and as the entire selection process has been cancelled without impeding them, comma, we are of the opinion, impeding them. We are of the opinion that liberty needs to be granted to the applicants to prefer the appeal against the impugned order dated, impugned judgment dated 3rd May 2023, passed in the writ petition being WP number
8506 of 2021.
Stop. Accordingly, the application for leave to appeal being such and such is allowed. Granted, is disposed of. Stop. We have been informed by the parties that similar appeals have been fixed for final hearing along with the connected stay applications on 9th of October. On 9th of October. In view thereof, list the present matter in the daily supplementary list of this court on 9th October.
At 2 p.m.
On 9th October.
At 2 p.m. It has been indicated in the earlier order.
9th October as fixed at 2 p.m.
এটা আমার 16 নম্বর একটা
Where is the original stay order? Mr. Debra, you have what was stayed? The notification and
original statement. This is the mother order.
ওটা না একটাই দিন প্রথমটাই দিন
এটা clarify করতে হবে।
Yes, it's not this stuff.
এরপর দাদা,
দেখুন হয়েছিল তো
আমাদের অর্ডার
এক্সচেঞ্জ
নাম অ্যাপ্লিকেন্টের নাম আচ্ছা আরেকটা লিখে দাও in connection with the present in connection with the appeal, an application for stay being can number such and such has also been filed. We have been informed by the learned advocates that in similar matters already an interim order has been passed staying the operation of the order dated 3rd May 2023, passed in WPA 8506 of 2021, and the notification dated 19th of May 2023. No, we have been informed critically in connection with the appeal, an application for stay being can such and such has also been filed. Stop. Considering the arguments as advanced, we direct that there shall be an interim order of stay of operation of the judgment dated 3rd May 2020 passed in such and such, and the notification dated 19th May 2023 till the
30th November.
Till the end of November 2023 or until further orders, whichever is earlier. List the matter list, ওই যা বলেছো, the daily supplementary list of this court on 9th October as fixed at 2 p.m. ওই ক্যান অ্যাপ্লিকেশন সেকশন 5 আর লিভ টু অ্যাপিল ডিসপোজ অফ করে দেবে, আর এই ক্যানটা পেন্ডিং থাকে। Yes, same order in
16, 17, 18, 19.
My lord, item number 17, my lord, I have no application for condonation of delay. My lord, I have no delay. My lord, can one is leave to appeal.
আইটেম নাম্বার 17 এ বলে দেবে যে নো সেকশন 5, তাহলে ওই অর্ডারটা আর দেবে না ওখানে, শুধু এটা তুমি পেন ড্রাইভে পাঠিয়ে দাও, প্রিন্ট আউট বের করো। 18 সেম,
And 18 days a delay of 20 days. Delay of 20 days. তাহলে 18
delay application আছে?
18টা সিমিলার হয়ে যাবে।
delay application আছে?
Can 18
18 will be similar to
section 5 application which can 1 or 2 or can 1 minus can 1 can 1 can 1 section 5
দেখে
and leave to appeal.
আচ্ছা তো লিস্ট টাইম ফাইলে আছে তাই নেই তো
কোথায় ফাইলে
on
অ্যাপ্লিকেশন তো নেই তো
ওই লিখে নাও না কেন?
can 1 আমি ওই জন্য বলি না can 1 section 5 and over the copy can 2 হচ্ছে
এক্সপেরিয়েন্স করতে এসব
আমি যে better you all keep copy. হ্যাঁ
আমাদেরও দিতে, আমরাও দেবো কপি 17.
copy
you
letter
have an extra copy,
My lord,
we will send you the Xerox charges.
my lord.
We will send you the Xerox charges, you heard it?
No, no, no.
You are saying, my lord,
No, 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 my
you
lord.
are asking money from the court.
No, no, my lord, no. Can one?
আচ্ছা, no, let us say that.
18 না
Let us go one by one. Who is in section, who is in item 16?
My lord, I am
16, what is your section 5 can number?
1.
Section 5 can 1, leave to appeal is 2. আচ্ছা,
Stay application is 3.
stay application. Item number 7.
My lord, I am.
Is the leave to appeal?
Yes, one is leave to appeal.
Given the copies.
17
17, my lord, I can, my lord, can 2 is stay. Can 2 টা দাও।
বের করে নিয়ে আসো।
লিখছি।
Section 5 no. For section 5 no.
My lord, I have given, my lord, handed over.
18
No section 5.
18 or
70 টাতে কোনো সেকশন 5,
19 এর application আছে।
ও 89 এ আছে, তাহলে আর 89 18 19 same order appearance টা দেখে নেবে। And which is any other matter?
No, my lord.
Item number 18, we have an additional prayer minor that is for production of the merit list. But that prayer perhaps is not there in the other applicant's file.
No, no, that is in your stay application. So your stay application is pending. We have not disposed of, we have only granted the interim order.
And item number 19, delay of 18.
I'm ready with merit list, no problem. Bundle up.
Bundle of merit.
Bundle up.
গ্রেটফুল my lord.
Grateful to you. Deep love like that.
Grateful, my lord.
May I find the affidavit of service? Affidavit of service.
Which matter?
18 and 19.
18 and 19 affidavit of service টা নিয়ে নাও।
16 এর দিয়ে দিই।
16.
Hey. Mine. তো পরে এসে দিয়ে যাবো, তাই তো?
Item number 28.
My lord, we are for the respondents in this case.
I am for the appellant, my lord.
My lord, kindly seize the order dated 3rd July.
দুটো কপি দিয়ে দাও হাতে যদি না থাকে affidavit
Section number?
I have also copies.
দাদা অ্যাপিয়ার করছেন অ্যাপিয়ার করছেন affidavit service
আর কি হবে? রিট পিটিশন ডিসপোজ
direction
My lord, this is the affidavit.
ঠিক আছে বুঝে গেল। ওটা সেটা বার করে নেবো। দেখতেছি কাগজটা কোথায় রে? ওই যে, সেটা দাও।
Heard the learned advocates appearing for the respective parties. Please give your appearance. Records reveal. No, records reveal. It appears that the present appeal has been preferred, challenging an interim order dated 25th April 2018, passed in a writ petition being WPA 4890W of 2018. Upore affidavit of service filed by the appellants be kept on record. Therefore, heard the learned. So,
on behalf of the respondents,
you
I
are
am here for the respondent. My
I'm for the
learned friend is
appellant.
that.
give your appearance. sir.
Parties, my lord, I said parties.
Affidavit of service is on behalf of the respondents. Lordship directed us to intimate them since they were not appearing.
On the last occasion, we were not there.
Affidavit of service, comma, as filed, comma, be kept on record. Here, you are hard the learned, no, sir. Passion. Stop. Stop. The writ petition has already been disposed of during pendency of the present appeal. The writ petition has already been disposed of by an order dated 14 November 2022. Stop. In view thereof, comma, the present appeal and the connected application. The present appeal has become infructuous and accordingly the same is dismissed. There shall, however, be no order as to cause urgent certified. Yes, next. What is it?
Lord,
Any urgency?
No. It's my appeal.
Disciplinary proceeding.
Yes.
Paper books ready?
Paper books are ready. Lord, we have filed the paper books.
How long will you take?
Lord, some time, Lord, because
If
he press time, it may affect on next.
The problem is my brother would not be here from Monday. He has a circuit.
Yes, ma'am. Then
So in that case,
then
we
after
cannot
cir-
finish
then
it
after
prior
circuit-
to the vacation.
then
Even if we finished, your judgment will be reserved. Here you. Bolo ki korbe?
then after vacation, your losses. Before
You are
vacation.
coming during the vacation, then we
No.
will come. To take the resolution, we will be here. No problem.
That is not. Before vacation, is it possible? If before vacation, if it's possible, not that after vacation.
No,
At all.
before vacation, we can keep it, but I will hear it with a different partner.
Right.
And after vacation, if the bench again changes, then you people will be on difficult. We don't have any problem. This is a problem. No issue.
After vacation.
Right, reopening.
Dismissed.
Dismissed employee.
Yes.
Allow-
Compulsory retirement. Compulsory retirement.
Compulsory retirement.
Punishment
Set
was
aside by
compulsory.
the writ court.
Not set aside. My Lord, the punishment was changed, altered.
That also you are not wanting.
Yes, my Lord. I have something.
Reduced to lower grade.
Yes.
Reduced to lower grade.
Yes. No, man.
Reduced to lower grade.
No, man. That is not so.
No,
Court had decided the matter. Some simple punishment was given. Simple punishment given. All the salaries which has been paid are dues, pay the dues also to the petitioner. Now they have come with the applications.
Oh, they have paid you the dues.
No, nothing. After having that, they filed an appeal, my lord.
No, you have been reinstated.
Reinstated.
You are working there.
No, reinstatement, my lord. No. Where reinstatement could have?
No, no, the what order did you challenge before the writ court? Compulsory retirement order? So it has been set aside.
No, it has not been set aside. The punishment, my lord, if your lordship
It has
sees-
been said that you give a lesser punishment.
Yes.
Yes, madam.
Oh, against that you have come.
Yes,
Yes.
So you have not yet joined.
Not yet joined, madam. In the meantime, retired, madam.
No, it's a lesser punishment.
In the meantime, retired.
What was the allegation? Oh, you have retired also.
Retired also in the meantime.
Got your pension.
Mr. Aurobindo.
So you have not got your pensionary benefits.
Nothing. For that reason, mention the matter, Mr. Aurobindo Chatterjee appearing.
Yes, Mr.
Mr. Akash.
Rai, why you are not giving him the admitted
Whatever the admitted benefits are, my lord, he has got, my lord. Nothing, my lord, only in terms of the order which is impugned in this appeal, my lord, if that is to be given effect to, my lord, that effect has not been given. But in so far, my lord, as the compulsory retirement, whatever he is entitled to, my lord, that he has definitely got. That cannot be his, my lord, allegation. The writ petition was not that. The writ
Yes,
petition
you
was
have.
challenging.
Have you got that amount?
What a simple amount was got.
Not sure. Suppose you have been compulsorily retired.
Yeah.
Compulsory retirement is different from dismissal.
Yes, madam.
You will get some benefits. Have you got those benefits?
After that instruction.
Much later.
Yes, madam.
Definitely.
Got it.
Yes. In terms of the order, my lord, which is impugned, those benefits, my lord, since we are in appeal, my lord, and
The paper. No paper book.
yes, paper book is there.
Huh.
ডিসেম্বরের 1 তারিখ 4 তারিখ
Mr. Mr. Aurobindo Chatterjee, who is appearing in this matter, he was in personal difficulties, he could not come to the court also.
He has not come.
Yes, come, he could not personal reasons.
ডিসেম্বরে মিট করে দেওয়া হবে 4 তারিখ 4 তারিখ
Hard the learned advocates appearing.
Lord, only one more respectful submission, Lord. Allahabad Bank, which is the appellant, Lord. This has merged with Indian Bank now, Lord. This, I just wanted to bring it to your Lordship's kind notice, Lord. That may be recorded in the order, Lord.
Now, then
Indian Bank.
Everybody
Indian
has
Bank.
to be changed, na?
Yes.
Lord, the appellant has changed. So Indian Bank.
Strictly speaking.
And that has been by way of
I've
a
served them.
gazette notification, Lord, that
I've served them, the appearance service may be kept in
Yes,
the
but we will give you leave, then you correct.
by hand.
very well.
You have to change the names of all
The appellant only, Lord, because the respondents will be
only
the same.
instead of Allahabad,
It will be Indian Bank. Yes.
Indian.
Other things will remain.
Yes,
same,
yes,
right?
yes.
That
Yes.
is.
Application.
No, it's fine. সব জায়গায় ব্রাঞ্চ ম্যানেজার তলা এলাহাবাদ ব্যাংক এরকম লিখতে হবে
No.
তো?
Indian.
হ্যাঁ।
এটাকে অ্যাসিস্ট্যান্ট জেনারেল ম্যানেজার দিছিল ইন্ডিয়ান ব্যাংক।
ঠিক আছে করে দিন।
The inquiry officer is still there or
My
retired?
lord, these may have, I do not know, my lord. Actually, my lord,
Then Mr. Rai, will you file a short application?
yes, my lord, that will be better. File an application. I will.
Who will be the actual appellants you incorporate? Mr. Rai, learned advocate appearing for the appellant, submits that Allahabad Bank had already been merged with
Indian Bank.
Indian Bank. In view thereof, he prays for leave to take necessary steps in the present appeal. Such prayer is considered and allowed. List the matter for further consideration in the daily supplementary list of this court on 1st December. The Mr. Rai would be at prays for leave to take necessary steps. The appellant is directed to take necessary steps in the
Great.
You affirm the application and give a copy to Mr.
Yes, my lord, definitely.
Affidavit of service, as filed we gave on record. Could you please give a copy? The copy of that addition, whatever you will file.
Yes,
give
yes,
an
my lord,
advance copy to.
I shall, Lord, I
We
shall.
will, on that day we will hear.
Yes, yes, I shall. Grateful.
Number 22, 23.
Let's interim order. Interim order support the purpose. Last occasion millet. প্রতীক প্রকাশ ব্যানার্জি অর্ডারটা কোথায়? লাস্ট সেকশন দাও এটা। Last occasion matter, it was fallen from your lordship whether there is a vacancy or not met. I'm glad to assist your lordship lad before the single judge milad from the beginning the direction was to keep 5 posts vacant and that interim order continued until disposal of the writ petition, and thereafter in before the appeal bench milad again that interim order continued. Therefore milad there must be vacancy of this post as directed by this honorable court. This is the first order. I'm sorry, milad, this is only one copy I have.
If the post have not been filled up today,
When did we hear it last?
Millard, the latter matter was last heard on, Millard, 14th of September 2023.
that's for 29.
And 29th on, and thereafter on 29th September. 29 matter was at 14th September, I think, this is by the division.
Yes.
That interim order continued until disposal of the writ petition milad, and thereafter the division bench also passed an interim order protecting my rights.
The order of the division bench, my lord, will be pleased to find at page 196.
195.
It starts from 195, relevant portion 196. Clear indication of the division bench.
তাই ভাবছি।
Last part for the the recording is single because the revision bench is needs correction that on 19th December 2019 the learned single judge passed an order. It records the learned advocate appearing for the response. It's an order of learned single judge.
No, you tell us the facts. You participated in the selection process. You
For
are from an university, Alia University.
Alia University.
For that, you are not required affiliation.
Approval from AICT.
AICT.
That's my point. That has been settled by the Honorable Supreme Court. AICT also circulates that. Now, that is the only ground on which they made me ineligible for the post. And that's why I have approached this Honorable Court.
No, where that eligibility criteria is at page.
Yes.
Where is the advertisement?
Page 101.
101C.
101C.
Page 101.
কোনটা আগে আছে? Yes.
Yes. Advertisement. 38 এ উদয় আছে। Looks.
101C, sub-assistant engineer.
That is also in page 38.
Yes, I am just showing from.
Also page 38.
Diploma.
Diploma in Civil Engineering from Institute College, duly recognized by any of the State Council of Technical Education. Your contention is that you are not a diploma holder, you are a degree holder. Degree holder from a university does not require approval from State Council.
Yes.
This is the case.
This is my case.
So what did the tribunal, what did the writ court say? That you
Court of-
participated, finished.
Yes.
That is
That's-
the ground, no?
That's the only ground.
Cannot turn back and challenge the
Yes.
selection.
Since you have not challenged the advertisement, my submission was I had no occasion to challenge it because it never debars me from participating. Having
You have a higher qualification.
higher qualification, and Lordship asked me to bring judgment to demonstrate that higher qualification is permissible.
No,
that-
that is our court has decided. That or, but
In fact, in similar facts,
No,
BTech
no,
degree I have.
your next argument was that being a state instrumentality, the law of the land should be followed.
Should be followed.
Now, when did this, on the date of the advertisement, there was still a requirement to obtain approval of
No,
State Council?
no.
Where is the Supreme Court order then?
Well, I have handed over it in 2001 when Supreme
the
Court has
judgment.
passed the judgment. Well,
To
কোথায় judgment টা?
page 194 was modified. Page 194, that is 23rd October 2019. Advertisement was in 2017.
Yes, yes.
17.
Subsequently, but they have in principle agreed in 194.
No, right, but when was the Supreme Court order?
Supreme Court order of 2001.
Huh?
No, I have handed over 2001.
That is that Bharati Darshan University.
Right.
Kindly see the judgment, my lord, whether
We have got the copy. Let him finish you.
Yes.
Yes,
Yes, my lord.
now Mr. Bhattacharya first tell us.
My lord,
are
I
there
have
any
taken the
vacancy?
instructions as far your lordship had indicated me that to take the instructions as to whether West Bengal State Electricity Distribution had given appointments to persons who were having degree from approved by AICT.
Yes.
This is the specific note sheet which I am giving, my lord, for the
তিনটে আছে একটা রেখে দাও
দাঁড়া কি
এই দুটো
তিনটে
আছে
Give a copy to your friend also.
Yes. My lord, this is the internal note sheet. Can
Oh,
you
acha,
see? This is a very confidential document of the particular board. Kindly see that, and because I told the authorities that you must produce your internal documents to the court.
What is your qualification, Mr. Amen? You
Like diploma in engineering, electrical engineering.
Diploma
sorry,
in
degree.
electrical engineering.
This note sheet is reflected in your order.
Yes.
We were wanting to know, have anybody?
No. My lord, I submit to my lords that no person who had no, I'm sorry. No person.
Yes.
No person having no approval from AICT, but having BTech or diploma, they have not been appointed.
So
All
where
persons
is that line, Mr. Bhattacharya?
Milord, kindly see this particular thing, Milord. At internal notification number, has my lord got it, Milord, in the first page. Then
You are talking about page 190.
no,
That
I am
2015-16 approval given. Prior to that, as there was no approval by the
yes.
that
Milord, I am just
technical-
may I, Milord, read this.
So your contention is that no person having BTech not recognized by
AICT or diploma in engineering, they have not been given appointment and there is no vacancy.
and there is no
No vacancy, I have taken the specific instructions.
Yes. Now you answered which was interim order. What you are showing that since postman.
I only one copy. May I hand over?
Yes.
But this is the last order passed by the single judge after this judgment.
Matter is ready. They have not taken it. The honorable submits that they have not taken any steps.
Up to January 2020, there was no appointment, and thereafter this appeal. Appeal could also pass an interim order protecting my rights. Therefore, my lord,
Then when did you hold this election, Mr. Bhattacharya?
this is something
This
like
is, this is for 2003, kindly see date of the
2019
advertisement.
order.
Yes, 18th of March 2017. Then, my lord, we had obtained a letter from my lord, the particular from the Alia University to the effect.
Restraining is a fee. The Learned Council applicant submits the applications made for extension. Page 196.
yes, ma'am. This I moved during COVID.
So that at that time only it was filled up. Those were filled up.
But they have submitted.
No, page 196.
Yes, it
Is that
appears that
not-
an interim order in the application restraining the respondent from filling up posting was expired in April. This is not correct.
No. Forget that. First, second, third, fourth paragraph. Kindly see.
In view of the matter, if the poster have been filled up, that the decision abides by the result of the appeal. Now, that is their submission during appeal that they have filled up the post. But there should not have been any occasion to fill up.
Your contention is that there are still vacancies and posts have not.
Should be, my lord, because up to January 2020, there was a protection of the single judge. And thereafter, I preferred appeal.
But admittedly, the interim order expired. Admittedly, the interim order expired. That is why you filed an application for extension. And that extension application, was that interim order expired in April 2019. April 2019, as it expired, you filed an application for extension.
And in that application, they say that there no steps have been taken for filling up the post.
That was in 19th of December 2019. Now the writ petition was disposed of by the judgment.
By the judgment on May 2020. So
13 May 2020.
in between January and May, there is
All right. What is your next argument, Mr. Ahmed?
Well, I was supposed to not cite this judgment only that on similar facts that Supreme Court in 2021 passed an order.
On the issue that the law of the land has to be followed.
No. This is on degree holder.
Huh?
This is on the degree holder. That was like last occasion it was a sought for this judgment.
No. We sought for your argument was that
One of the
suppose
argument was this, yes.
qualification has been made, like higher qualification is not a bar. So it needs to be read into it. And if we have understood your argument that on the date of the advertisement, there was no such requirement.
Right.
So that non-requirement needs to be read into the rules.
Right.
This is your argument. And the trial judge said that no, you did not.
You should have
challenge the
challenged.
advertisement.
Yes. That's all, nothing more.
Yes, with judgment you are placing, Mr. Ahmed.
That this judgment if you require only then I can cite.
Which paragraph, Mr.
That second paragraph, the issue whether a degree in
May I get the reference?
yes
to the judgments?
2021 SCC online Supreme Court 21 SCC online Supreme Court 291. Second paragraph, the issue.
You Mr. Bhattacharya, take this
No, I am just
so that you can reply.
আর কপি আছে?
চলো।
কপি আছে?
Thank
you. Yes.
Whether degree in engineering, electrical and electronic engineering is technically a higher qualification than a diploma in that discipline, and whether a degree holder are eligible for appointment to the post of junior engineer electrical under the relevant recruitment rules is the issue that falls for decision in this appeal arising of a common judgment of so and so. Then straightway takes up that Paragraph 23. The question whether the stipulation or prescription of a particular academic qualification excludes an applicant who possesses what is termed as a higher qualification from their candidature to the concerned post has often arisen for consideration by this court. In so, the issue which arose for consideration was whether for primary class teacher the prescribed qualification trained certificate included those who held B.Ed degree. This court was forthright in holding that the B.Ed qualification could not be considered as a higher qualification than TTC, and that the TTC qualification was given to a teacher specially trained to teach small children primary classes, whereas those with B.Ed were trained to impart education to students of a higher class. Then we'll state where paragraph 29 onwards.
So B.Ed was not treated to be higher to TTC.
Yes, that has been considered then. Paragraph 31 is a decision. As far as the merit of the main question is whether the degree holder can apply to the post of JEs. A close examination of the rules shows a lion's share of the post at JE level is set up apart from direct recruitment. However, when it is at the level of the higher post, that is assistant engineer, which is a promotional post, direct recruitment is only to the extent of 36% of the balance 64. Various subquotas have been stipulated for feeder cadres, the largest percentage being for the junior engineering. For long time, even on the date of advertisement, 2 district quotas, that is so has been set apart from the promotion of junior engineers holding the degree qualification in the concerned subject. This court is conscious that issue is in question is whether minimum qualification of a diploma in electrical or electronic engineering or other prescribed qualification includes a degree in the discipline. However, the rules have to be considered as a whole. So viewed, the 2 subquotas are, then the quotas has been quoted, then paragraph 37. It would also be relevant to notice that in the appeal, it has been specially averred that so-and-so has been making contractual appointment from amongst the degree holders in the cadre of junior engineers, and an order was issued upon the recommendation of the screening committee, which through its meeting held on so-and-so date had cleared the regulation of 28 such candidates. These degree holders are equivalent to the juniors and had been working for a periods ranging between 4 to 6 years.
Yes.
Then paragraph 40, 38 and 40 court decides for the foregoing reasons, these batches of appeal by a degree holders have to succeed. The respondent is directed to process the candidature of all the applicants, including degree holders who participate in the, and depending on the relative merits, proceeds the issue in final selection test of all successful candidates after holding the interviews, etc. Degree holders were allowed to participate in that. I was trying to find out on similar facts, but this judgment I got.
No, you showed us para 2, then you showed us para 23. Right? After 2, you showed us 23, na?
Yes. Para 23. Then para 31, 32, 37, 38, and 40.
Yes. And this Bharati Dasan University is from...
Yes, Bharati Dasan University, basically 18 SCC, page 676.
Yes.
Paragraph 15 is a decision, Malad. To put it in a nutshell, a reading of section 10 of AICTE Act.
Paragraph 16.
15, 15. Paragraph 15 summarizes the entire thing. Section 10 of the AICTE Act will make it clear whenever
Act omits to cover a university, the same has been specifically provided in the provisions of the Act. For example, while under clause K of section 10, only technical institutions are referred to, clause O of section 10 provides for guidelines for admission of students to technical institution. Universities imparting technical educations, if we look at the definition of technical institution under section 2H of the Act, it is clear that the technical institution cannot include a university. The clear intention of the legislature is not that all institutions, whether university or otherwise, ought to be treated as technical institution covered by this Act. If that was the intention, there was no difficulty for the legislature to have merely provided a definition of technical institution by not excluding university from the definition thereof, and thereby avoided the necessity to use alongside both the words technical institution and the university in several provisions in the Act. The definition of technical institution excludes for its purview a university, when by definition a university is excluded from a technical institution. To interpret that such a clause or such an expression whenever the expression technical institution occurs will include a university will be a reading into the Act what is not provided therein. The power to grant approval for starting new technical institution and for introduction of a new course of programs in consultation with the agencies concerned is covered by section 10K, which would not cover a university.
This
But
is your turn.
yes.
All right, thank you. Yes, Mr. Bhattacharya, anything in reply?
Yes. My lord, I only want to submit to my lords, my lord, apart from what I have submitted, that my lord, kindly see this judgment of 2001 volume 8 SCC 676. Bharati Darshan, this now what I want to submit to my lord, subject to what falls upon my lord's kind consideration, that the approval of AICT is not required. AICT approval is not required. This, my lord, subject to correction, I could not find out in the judgment. A specific submission. Now, my lord, I may submit to my lords that your lordship may kindly consider that there were certain, my lord, qualifications indicated in the advertisement. He did not fulfill the criteria. There was a letter which was sent by the Alia University. Because we wanted clarification from Millard as to whether Millard he fulfills the criteria. My lords have taken note of at page 101M of the paper book. They had indicated that BTech courses offered by Alia University. Yes. I need not, Millard, apprise the same facts. Now, what I want to say, submit, first of all, Millard, after participation in the selection,
You cannot challenge.
You cannot question it. This is well settled. I need not, Millard. Second, what I want to submit to my lords, that the criteria or the qualifications required for the post.
So, Mr. Bhattacharya, tell us one thing.
Yes, my lord.
Suppose, as it happened in the case of Anganwadi worker, special bench judgment,
Yes,
which was
yes.
Now, higher qualification is not a
Not a disqualification.
Now, suppose I am the employer. I publish an advertisement saying that I require diploma holders.
Yes.
In that case, am I not bound to allow persons having degrees to also participate?
Yes, that we have done.
So, if that is done,
yes,
then what is your contention to this answer? That once the graduates, once the degree holders are allowed to participate, irrespective of the fact of approval,
Yes.
irrespective of the
Yes.
factor,
Yes.
then you are acting contrary to the law laid down by the court.
No, what I am submitting, I understand, Miller, possibly your lordship is indicating there are two particular, Miller, mandamus appeals which have come up for my lord's kind consideration. One is Muhammad Johidul Islam, another is Shahar Ali Lashkar. Johidul Islam is for diploma holders, and Johidul is for the graduates. Shahar Ali, Miller, I stand wrong. Shahar Ali is for, Miller, kindly see, Miller, that's the reason I wanted to indicate to my lords.
What you are saying, Johidul is?
Johidul is, Miller,
One
diploma.
judgment delivered. One judgment delivered.
Yeah, no,
All the merit petitions.
One judgment was delivered by taking into consideration the two.
No, all the writ petitions were taken.
Miller, I should check up. Before I make a submission, I should check up.
Johidul is there and Shahar Ali is there, right?
Yes.
So Johidul is for graduates.
Yes.
Johidul is graduates.
Johidul is diploma. Johidul is diploma.
Oh.
And Shahar Ali is for graduates.
Shahar হচ্ছে degree.
I'm grateful to my lords.
They were allowed to participate.
Yes, they were. There is no. Now they were allowed to participate.
Higher qualification of সেটা বলছি না, যে হায়ার কোয়ালিফিকেশন যে বাড় নয় সেটা আমরা ডিগ্রি ডিগ্রি হোল্ডার কিন্তু ওরা ভেরিফিকেশনে গিয়ে দেখতে উইদাউট দিস ডিগ্রি তাহলে ডিপ্লোমা দিল না বুঝতে পারে রিকগনিশন বলতে না সিনিয়র তো পাঞ্জাব জুনিয়র ল যে দেরিস মশা যায় রানিং কমিটি সিনিয়র তো No, Mr. Bhattacharya,
yes,
is your answer to this?
Which one?
So, Johirul was diploma. He was not having approval from AICTE. Finished. But what about the degree holder?
Degree holder, same. Miller, the communication.
Mr. Bhattacharya, this degree holder, if he has obtained the degree from a university,
yes,
then the Supreme Court says
yes
that there is no requirement to take approval.
Miller, I submit to my lords, Miller, if your lordship, that was what I was trying to, Miller, make the submissions, Miller. Miller, I submit to my lords, Miller, your lordship may kindly take, Miller, I had taken the pains to read the judgment of Bharati Darshan.
Kindly come to
Paragraph, yes, what he has referred to, Miller, kindly come to, I should submit to your lordships, Miller, just 1 second, Miller. Yes. Kindly see this particular judgment of 2001 volume 8 SCC 676 of Bharati Darshan that deals with the case as to whether university is required to take the particular approval. Now, while referring, this is in the head note. Miller, there is a severe thing, Miller, in the particular judgment. Now, when I read the judgment, where is the particular line or where is the particular observation in the judgment that this is not required?
Kindly come to page
paragraph. My learned friend had referred to paragraph 15, 14, 15. 15.
Kindly come to middle portion of para 15.
Yes.
The power to grant approval.
Yes, Miller, just
Got
1
it?
second, Miller. 1 second. Power to grant approval, yes, for starting new technical institutions and for introduction of new courses or programs in consultation with the agencies concerned is covered by section 10K,
Hmm.
which would not cover a university.
Yes.
Yes, I say, my lord, here there is no indication that no approval is required. My lord, kindly say, I have brought the particular provisions of the.
No, please continue.
Yes, I'm sorry, my lord.
10K not cover a university, but only
yes,
a technical
would not cover a university, but only a technical institution.
Now let us stop here.
Yes,
So
yes.
if a degree is granted, say by a technical institution,
Yes.
then approval has to be taken from AICTE.
My lord, kindly see section 10K of the particular, my lord, this.
Acha, you finish up and
Yes, I am just because, my lord, it is well settled, my lord, that my lords have laid down the law that a judgment is not to be construed as a Euclid's theorem. It has to be seen, my lord, in respect of the statute.
Section 10K.
My lord, I am handing over to my lords.
Omits to cover. Section 10 is for grant of approval.
My lord, I am handing over to my lords, All India Council for Technical Education Act 1987. My lord, I am just handing 2 copies. Just 1 second, my lord.
Thank you.
My lord, that is it.
Picture. Functions of the council.
Yes. Kindly see section 10K.
Hmm. So this is in case of new approval. That is what you are saying.
I submit to my lords, my lord, that is what I find, my lord, after reading the statute. I leave it to my lords. That's the reason I brought this particular provisions of the statute. Now, and more particularly, as your lordship was indicating, that it is not required in respect of.
So your argument is the image is blurred, that actual exclusion is there or not. Furthermore, Alia University itself has said that we don't
He
have
himself, my lord, this letter shows that. This letter shows that. Because we are a statutory body, we are.
What is your understanding? Tell us. Today, suppose I am the employer. I publish an advertisement.
Yes.
In the advertisement, I say that only diploma holder required.
Yes.
But the law of the land is graduates can also degree
Higher
holders.
qualification is not a bar.
Higher qualification. So you are giving higher qualification participation.
Yes.
So in the same manner, when you are following the law of the land, why will you not apply this proposition that once I give a degree holder from a university to participate, I will not insist for approval of the council?
That I cannot do because of this communication of the Alia University. These and Millard, kindly see that whether Millard, this letter of the university was under challenge.
ওরাই তো আলিয়াকে লিখেছে, তাও করেছে পার্টিসিপেট করতে। তারপর আলিয়াকে জিজ্ঞেস করেছে যে তোমার কি অ্যাপ্রুভাল আছে,
ঠিক করছো, ডিগ্রিটাও কিন্তু নট বিটেকটাই ডিগ্রি।
হ্যাঁ হ্যাঁ,
বলেছে ডিগ্রিটাও নট
candidates with BTech was completed in your requirement and the instrument as well were allowed under to participate. Learned advocate has requisitioned certain specific pertaining to recruitment notification. Recruitment notification এ বলছে higher qualification দিচ্ছি আমি, allowed. তারপর ট্রেনিং এন্ড প্লেসমেন্ট had confirmed যে এদের রেকগনিশন অ্যাপ্রুভালটা নেই, এই ডিগ্রিটার অ্যাপ্রুভাল নেই, সেই জন্য আমি দিচ্ছি। কিন্তু এই ডিগ্রিটার অ্যাপ্রুভাল তো রিকোয়ারমেন্টই না।
And there is no challenge also with regard to the advertisement. Because my lords, I had placed before my lords, your lordships have also played, my lord, very well, your lordship is very well, my lord, familiar with this judgment of EIR 1990 Supreme Court. My lord,
Madanlal.
yes.
Madanlal.
No, not Madanlal, NT Bevin Ketty. That my lord, on the date of advertisement, the rights of candidates stands crystallized on the basis of the terms and conditions in the advertisement. My lord, I'm just handing over to my lords.
On the date of the advertisement.
The terms and conditions of the advertisement, as it was, the rights of the participating candidates stand crystallized on the basis of the terms and conditions of the advertisement. Now, unless, my lord, if there is a challenge with regard to the advertisement, nothing, I say, my lord, then, my lord, it is for the court to decide.
Then why did you allow graduates to appear?
No, we had kept an open window for everyone. If you are as your lordship had indicated, you know, kindly see, my lord, as an employer, when there are various particular persons and we fix up a criteria, if there are higher candidates having higher qualification, as your lordship was indicating, we are bound to give them, my lord, permit them to appear in the interview.
This 1990 Supreme Court.
1990 Supreme Court, my lord, paragraph 1990 Supreme Court 1233, paragraph 10 and 11. Kindly see paragraph 11 is more than sufficient.
That is on an aspect as regards that Rangaiya date of.
Yes, and kindly see, my lord, there in the in paragraph 11, what I had indicated to my lords, this specific line, my lord, has been indicated that after 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. After 16 lines from paragraph 11. Generally, a candidate has a right to be considered in accordance with the terms and conditions set out in the advertisement, as his right crystallized on the date of publication of the advertisement. However, he has no absolute right in the matter.
এটা বলেনি যে approval দরকার। কিন্তু আইন বলছে যে approval দরকার। সেখানে আমি কেন বুঝছি
জানতে চাইছেন, জজ এগুলো জানতে চাইছেন অপ্রাসঙ্গিক।
That's not.
if it crystallizes on the date of advertisement, Mr. Bhattacharjee, then you can allow only diploma holders to participate.
No, we will not kindly see that there are, just 1 second, Milo. I'm just 1 second.
Subsequently, modify code.
একটা তো সাব অ্যাসিস্ট্যান্ট ইঞ্জিনিয়ারের ডিপ্লোমা,
Kindly come to page 194, Mr. Bhattacharjee.
Page 194. I was just opening it.
194, realizing that you yourself modified the condition.
Yes, I submit, Miller. Kindly see the date.
90.
23/10/2019.
Advertisement was an 18.
Yes.
After that.
After that.
No, after.
We cannot give a retrospective effect to it.
Where is this Alia letter?
Alia letter is at page, my lord, 101M. Just kindly see, my lord, the language is very clear. Even had there been any confusion, my lord, because I told the also the authorities, my lord, to
থেকে 14 থেকে 14 অব্দি দেয়নি।
4 বছর করতে হয়ে যায়। কোর্স তো 4 বছর।
Judgment
থেকে
হয়েছে,
5 বছর। 5 years।
judgment হয়েছে কোন জায়গায়? Supreme Court এর judgment হয়েছে। All right.
These are my responses.
That so far, but this letter is considered simplify it. But today, this administrative communication between BCDCL and Alia is there. Now, and the Supreme Court in one hand. But which one will prevail? Whether this letter or the judgment of Supreme Court? Most certainly, judgment of Supreme Court will prevail.
Have you taken that ground, Mr. Ahmed?
No, but these they have disclosed in affidavit.
This is your argument.
These they have disclosed in affidavit.
Yes, no.
Before that, they have not.
No. In the grounds of the writ petition, you have not
nothing.
I have taken this Alia. No, Alia point I have taken because this communication
This argument which you have advanced,
today now.
law of the land has to be followed.
Oh, that I have taken. That I have taken in my writ petition itself. Kindly similar. I have said in otherwise.
Let us see.
Kindly takes up page paragraph 19 of the writ petition, page 19. I have not said the judgment. I have said that no approval is required.
Yes, that you have said.
Paragraph 14. Paragraph 14, paragraph 19, I have specifically said that no approval is required.
Ashok, the learned advocates appearing for the respective parties have concluded their arguments. Judgment reserved.
Much obliged.
Yes, sir. Have you got the information?
I found also the corporation, large advocate of the corporation, Saurabh Chaudhary also.
Because 2 p.m. we have our original site and we have another fixed matter. So we kept it at 12.
There is some difficulty with Mr. Chakraborty and the large advocate of the corporation also. That is,
If you cannot.
this takes the matter on a Friday.
Friday. Let it be there at 12 noon tomorrow. You intimate Mr. Bishas. You intimate them. If they come, we take. Otherwise, it will.